Hey guys, had a small feeling that we might be back today, but I didn't think it would be for this. This is huge in my opinion. So remember, we have two Judge Jennifers. Judge Rochon was originally hearing all of the earlier stuff in these companion cases involving Fat Joe, Terrence Dixon, Tyrone Blackburn, Roc Nation, and a million other parties. Well, that case was handed over to Judge Jennifer Willis, although some matters still seem to be in front of Judge Rochon. And we just got done discussing this morning that depending on which judge is dealing with an issue, will a repeated pattern of bad behavior, misrepresentations by Tyrone Blackburn go unchecked, and grace will be extended once again with just a verbal warning, or will there be something done to deter the future behavior? And now we have an order coming down from, and I'll show you the docket because it's going to be a bit complicated to follow. It's on the Dixon v. Cartagena et al. Docket. It's going to be so good. This is the order granting Roc Nation, who's a defendant in Dixon v. Cartagena. It's granting their motion to strike Tyrone Blackburn's opposition to their motion for Rule 11 sanctions. The basis for wanting to strike that opposition was the use of AI hallucinated, quote, citations from cases. And you heard me mention in previous streams where there's been this back and forth through the letters where Roc Nation's like, hey, can you take a look at this and strike this opposition? It's not even using real quotations. And then a letter was filed in response to that letter by Tyrone Blackburn saying, they're using AI citations. And if anything, I might have gotten my quotes wrong, but the cases exist. And then Roc Nation files in response, no, our quotes were not using AI. They exist. These are all accurate quotes. And that's not an excuse for someone else to use AI citations. So there's been a whole mess. That's largely what this centers on. But even more so than just this judge granting the request to strike Tyrone Blackburn's opposition filing because of the use of AI and its other representations, she also says she's going to grant the Rule 11 motion for sanctions as unopposed. I'm sure Tyrone Blackburn's going to appeal that. That decision is going to be written out, so it's not filed yet, but she does say she's going to file it and grant that motion for Rule 11 sanctions. Rule 11 sanctions, in short, you guys, it's a safeguard against frivolous filings. It's a safeguard against, if you're an attorney and you're trying to bring a cause against somebody, you don't just take some random law and say, oh, that sounds good. We're going to say that this is the statute we're citing under just because we want to file something against you. So you're supposed to verify that you're using proper statutes to bring your causes of action forward. You're supposed to do due diligence to make sure that the claims that you're putting forth, the accusations you're making in a pleading, have some meritorious basis. And there's a couple other things that Rule 11 covers. With that being said, I don't know what the judge is going to say in their order, but it's the same judge that's penning this order we're going to read now. And then we'll go at the end of the back end of this stream. We'll take a look at Alex Spiro on behalf of Roc Nation's arguments for Rule 11 sanctions. So it's going to be a time. Will he be late in filing that appeal? To be honest, sometimes when it pertains to him, he's pretty quick. He'll miss deadlines in relation to his client, sometimes leaving his client out of the response entirely. But it seems like sometimes he gets his own stuff, like cover his own ass in time. So let's get to this order, you guys. This is something I read before I went live with you, and I was dying laughing, and I just should have blind read it with you guys. I'll probably still laugh again. So again, we've got the two companion cases, both court listener dockets. Court listener is, it's a way that if somebody's buying documents through Pacer, some of those documents can become available to the public without additional payment or access to Pacer being required. So sometimes I'll link the documents I purchased directly because it's not always instantaneous. But if you give it an hour or so, if there's something I've bought or /star has bought a lot of documents in this case, or anybody else, typically after some time has passed, you guys can go to Court Listener, grab the documents for free and not have to deal with signing into Pacer, which is really a pain in the butt. or paying when somebody else has already purchased the documents. So Court Listener is awesome. It has its flaws, but I'm not going to complain. So that's linked in the description if you guys want to go and like explore. Whenever I show this screen, this is Court Listener with these color schemes. So companion cases. Got the 2 companion cases. Judge Jennifer Willis, the newer judge. The court is in receipt of the opposition to Roc Nation's motion for sanctions. Again, this is Rule 11 sanctions, filed by attorney Tyrone Blackburn. And then let's see. The court is also in receipt of Roc Nation's motion to strike Blackburn's opposition filing and to require Blackburn to file a compliant opposition. So that was what Roc Nation filed in its, once they saw that there was this AI-riddled response, they were like, hey, you should strike this, and if not, you should require him to resubmit a compliant opposition. Right? Kind of giving Tyrone Blackburn, giving the court a way to give Tyrone Blackburn a chance to remedy something that he shouldn't have been doing anyway. The judge is going to take it further than what Roc Nation requested. So they also wanted to strike Blackburn's response through one of the letters that he filed. For the reasons stated below, the motion to strike Blackburn's opposition to the motion for sanctions is granted. So that's going to be stricken from the record. And that's that like 65-page whopper where I was like, I've been putting off reading it. I was trying to read it over the weekend. It seemed weird. We then come to find out that it might have read weird because the quotes aren't real. And now that it's stricken from the record, I'm kind of glad that we didn't spend that deep dive time reading 65 pages of it. But we'll look at it a little bit. And then here is the banger. Here is the banger, you guys. The motion for sanctions will be considered unopposed. So this option where Roc Nation's like, hey, make Blackburn file a compliant opposition. The judge is like, well, I'm going to do the motion for sanctions without opposition. I'm going to do the motion for sanctions based on just what Roc Nation filed in its initial request. That is a huge, huge thing. Huge. A separate order on the motion for sanctions will follow, and I anticipate, this is 7 pages here, I anticipate that this order relating to the sanctions will not just be like a quick 1-pager. So it might not be super long, but I imagine there will be some meat and potatoes and stuff worth reading whenever that hits the docket, and we'll refresh before we end the stream later. On June 1st, this is going through the timeline, June 1st of this year, Roc Nation filed a motion for sanctions against defendants Dixon, Blackburn, and T.A. Blackburn. They're going to just call those the defendants. And again, this is a bit confusing because there are the companion cases. Roc Nation isn't a plaintiff in any of these companion cases. They're not part of Cartagena v. Dixon at all as a party, and Roc Nation is a defendant in the case brought by Terrence Dixon. But just so we keep it clear here, for the purpose of this order, Dixon, Blackburn, and the law firm are going to be referred to as the defendants. This court set a briefing schedule requiring defendants' opposition to be filed by June 30th, 2026. On July 1st, which is not before June 30th, Blackburn filed defendants' opposition motion. Counsel for Roc Nation filed a motion to strike the filing because it was untimely, exceeds this court's word limit, and contains what appear to be AI hallucinated citations. On July 7th, Blackburn filed a response to the motion to strike, in which he argued that because every case cited to is real, and this is a quote in the order, this is the judge quoting Blackburn. Each was cited for a proposition it actually holds. That's the end of the quote. That the allegation of AI hallucinations is inaccurate. Blackburn does not dispute that on 17 occasions, he included, that's the number that Roc Nation charted out. We can look at their letter. He does not dispute that on 17 occasions he included language in quotation marks. Chat, what do quotation marks mean? What are they used for? That is not identical to language in the cited cases, but states that, and this is another quote from Blackburn's writing, that where quoted language does not track the source verbatim, it is a paraphrase or compression that faithfully states the court's holding, the ordinary work of legal argument, not the invention of fake law that the AI hallucination cases condemn. Is this why you're supposed to use quotations? To paraphrase? What are we doing? What are we doing? In addition to defending the choice, and I love this wording, because I can just picture someone like saying this, like, with their eyebrows raised while they're writing it. In addition to defending the choice to quote language that does not exist in the cases cited, Blackburn accuses Roc Nation of, quote, failing the identical citation audit. So he did the, nuh-uh, you did it, defense in responding to Roc Nation's letter, and includes a list of 40 citations that he alleges are not reflected in the cases verbatim. So in response to Roc Nation's letter, this dueling ping-ponging letter, you're saying I had 17 examples, I'm going to call out 40. And then he represents to the court, Blackburn represents to the court, that 40 citations fail this AI audit. In response to Blackburn's filing, counsel for Roc Nation filed a letter informing the court that Roc Nation did not use AI in identifying authority for its own motions, nor in reviewing the authorities cited in plaintiff's opposition. And for what it's worth, this is Quinn Emanuel. This is Alex Spiro's law firm. It's a huge law firm. Likely just using a template for such an issue. And if you have a template, then that, like, if you have so many cases, you're so busy, you're short on time, you're missing deadlines, the type of scenario where someone might weigh the risks of using AI to help them get their case filings done in time, I'm not going to say that big firms aren't using AI tools and that big firms, lawyers from big firms, haven't been caught using AI hallucinations. But there's also a good chance that they already have templates for dealing with certain types of things like opposition filings, Rule 11 sanctions that they can pull from and say, all right, we already know these cases. Let's check to make sure that they haven't been overturned by a newer case. And then you can kind of plug and play. Something that would be faster than trying to do an AI research tool. But according to Blackburn, it must be AI. So Roc Nation's like, no. So they say, regarding the accusation of the 40 instances of misleading or inaccurate quotations, Roc Nation stated that it also appears that some of plaintiff's accusations are based on hallucinations from the very assisted citation verification tool plaintiff claims to have used. So here, there's a comparison. You can tell the judge is being detailed in how they're reviewing this. So the judge here is taking what Blackburn claimed Roc Nation included in its filing compared to what actually is in that filing, paragraph to paragraph comparison. And the reason this is so big for me to see is this is not the first time that the judge has had to do this. Judge Rochon had to do this. Sit there side by side when they were going into interrogatory responses in January of this year. And Blackburn, in preparing interrogatory responses, was taking like interrogatory number 14 and saying he pasted it and was replying to it, but the supposed pasted number 14, interrogatory number 14, didn't match the primary text. So they had to have a whole hearing where the judge had to read the paper and go one by one. And Mr. Blackburn, what did you mean when you responded to this? Because it doesn't even make sense to what the original interrogatory filed by Fat Joe actually says. Like, this isn't the only time that there's been this, like, piecemeal, quote-unquote, mistaken verbatim pasting, copy and paste that isn't a copy and paste. So anyway, this paragraph that Blackburn claims Roc Nation wrote reads, misattributed a quotation to a Supreme Court authority. Roc Nation attaches substantive bad faith language that a party filed a frivolous lawsuit in bad faith for the purpose of extorting a settlement from the defendants. To Bridge v. Phoenix Bond and Indemnity Company 553 U.S. 639 2008. The verification tool returned no matching quote found in Bridge v. Phoenix Bond and Indemnity Company 553 U.S. 639 2008. Bridge is a RICO standing decision. It does not contain the quoted language Roc Nation attributes to it. That is precisely the species of citation error, quoted language that does not appear in the cited authority, that Roc Nation labels AI hallucination when it appears in plaintiff's brief. then back to the judge. The judge is like, however, Roc Nation states, and then this is the inset quote, had plaintiff actually read Roc Nation's motion, he would have seen that Roc Nation did not attribute that quotation or any other to Bridge. Roc Nation cited Byrne v. Netzhat, 261, 3rd District, 1075. I need to learn how to read these citations, from the 11th Circuit in 2001, and appropriately added as a description of subsequent history that the decision was abrogated on other grounds by Bridge. See docket number 204 at 13 to page 13 through 14, or paragraph 13 through 14. So in addition, this is back to the judge. In addition to Roc Nation's representations in their letter, the court verified the quotations and citations in both the motion for sanctions and motion to dismiss. So the court sat here and did the human verification. "17 examples," and she might have gone beyond that, because if I remember in Roc Nation's letter, they said this isn't an exhaustive list, but here's 17 examples that we pulled. I don't know if the judge just went with that, or if she went through every citation in all of the filings or what. But she's saying here that she verified the quotations and citations in both the motion for sanctions and the motion to dismiss. And then they say this court is deeply troubled. Deeply troubled. 1. Blackburn's use of language in quotation marks that does not exist in the cases he's citing the language for. 2. Also deeply troubled by Blackburn's insistence that his behavior is acceptable because the cases exist even though the quoted language does not. 3. Blackburn's attempt to defend his behavior by lodging unfounded allegations. And that's very important wording, because it's different than saying two wrongs don't make a right. This is saying you're trying to right your wrong by making something up and saying the other person did it instead. That's very different than saying Roc Nation also did it, but that doesn't excuse your behavior. It's unfounded what you're saying Roc Nation did. And 4, the court is deeply troubled still by a continued pattern of behavior by Blackburn of making misrepresentations to the court and memoranda of law after being sanctioned by multiple courts, including this one, for doing so already. So Judge Willis has already sent a referral to the grievance committee because of Blackburn's behavior in these underlying cases. And Willis hasn't even been the judge the whole time. Let alone the other courts. Blackburn in his filing attempts to obfuscate the meaning of a quotation and how to use quotation marks. Therefore, the court will provide definitions. Merriam-Webster's dictionary defines the verb quote as, quote, to speak or write a passage from another, usually with credit acknowledgement. See, quote, Merriam-Webster Dictionary, last visited July 8th, 2026. So we're just gonna pull it up. Let's do the pronunciations. Oh, why
Quote.
can't I hear? This is in her order, guys. This is when I stopped and I'm like, I just gotta do this live. Oh my god. To speak or write a passage from another, usually with credit acknowledgement. To repeat a passage from especially in substantiation or illustration. To cite an illustration. To state. To give exact information. Oh my goodness. Oh wait, this is one of the letters, I think, right? Hey, why did this scroll back up? Where were we? We were page 4. Yeah, go right back to this hyperlink. That's where we left off. It says www.merriam-webster.com/dictionary/quoted. Oh my gosh. Merriam-Webster defines quotation mark as one of a pair of punctuation marks with the examples used chiefly to indicate the beginning and end of a quotation in which and this is emphasized, in which the exact phraseology of another or of a text is directly cited. Oh my goodness. So now we're defining quotation mark. I didn't read this part. I didn't realize I stopped after learning that we were going to define quote today. I did not know we went on to further define quotation mark. She's saying that she added the emphasis. The Blue Book, which provides guidance on how to use quotations from case law, gives specific instructions for how to substitute or omit letters or words when quoting language from a case. Cited here, the Blue Book, a uniform system of citation. Oh my gosh. Not only does the dictionary define, if I keep laughing, I'm going to make us watch the deposition clips until I stop. Not only does the dictionary define what a quotation is and how quotation marks are used, courts expect lawyers to present accurate quotations and citations in written submissions. Oh my goodness. Wait, is this Christopher Boozy? Oh my god, they're citing the Chris Boozy case. Because he used a quotation. He put like an ellipses in a quotation, but skipped like 6 pages of text with the ellipses. This has to be the Chris Boozy case. It's Southern District of New York. Do you guys know what I'm talking about? Chris Boozy, he was like, he did some bot checker thing in the Amber Heard case. Oh my god. This is so funny to see him quote the case quoted here. This is like a memory unlock. Oh my gosh, I can't believe this. Oh, anyway, that would be a side story, but if you know the name Christopher Boozy, or if you remember the long ellipsis saga relating to Boozy, I'm blocked by Boozy on Twitter, when it was still Twitter. And I think I'm on several of his block lists, so people that use his automatically block people who talk about cases. I see a lot of people that have me blocked on Twitter, and I always just assume it's from like the Amber Heard days because I was on some list where you can like, I guess on X you can import lists of accounts that you want your account to just block in mass, and I'm on that list. So, oh my god, that is crazy to see Boozy. That is a throwback. So anyway, when a party uses quotation marks, this is from the Boozy case. When a party uses quotation marks to delineate statements of legal rules, and those rules are followed by a citation to an existing legal case, the court treats this as a representation that the cited case contains the language which is in quotation marks. The court does not look kindly on failures to accurately represent cases cited by a party. No, it's literally Chris Boozy, you guys. Justin says we were all blocked by Boozy. Oh my gosh, can we bring that hashtag back? My goodness. Oh my gosh. This is a time. This is the time. And hey, everybody. I'm gonna stop and say hey to you guys eventually. But this is the time. Let's keep going. All right. We were like here, right? Rather than take responsibility for the inaccurate representations in the opposition motion, Blackburn made baseless accusations against counsel for Roc Nation in an attempt to deflect attention from himself. This is not the first time Blackburn has made unfounded accusations against opposing counsel in this case. Blackburn was recently sanctioned by this court for that very behavior when he accused counsel for Cartagena of violating the protective order without a modicum of evidence to support the accusation. So we read that about like 2 weeks ago, maybe. And what's interesting is also happening, we talked about it this morning, there is a battle over an order to show cause in the Cartagena v. Dixon case. Well, I guess it's kind of in both because the motion to withdraw is in both cases. But it's really in response. Cartagena's team sent in an emergency letter written by Joe Tacopina asking for the sealing of certain exhibits that were included as attachments to the affidavit in support of Tyrone Blackburn's motion to withdraw. And we just read this morning Tyrone Blackburn's response, where he says this doesn't violate the protective order because it's not really discovery information. It's not discovery material. I didn't violate any rules. So we have like a reverse saga going on with all of that now. And the judge here is emphasizing that when when Blackburn made a similar accusation against Fat Joe's team, he was sanctioned for it because it was completely unfounded. Furthermore, this is not the first time a court has stricken filings by Blackburn from the record because he fabricated quotes from case law. On June 25th of 2025, a court in the Western District of Pennsylvania stated, this is going back to Youngblood, when reviewing Blackburn's briefs, the court was perplexed to see quotes attributed to the court's own prior opinion in this case, as well as other case law that was wholly fabricated. And that's from Jakes v. Youngblood. And again, we just read earlier this week, we looked at in the Kings County criminal case, in the judge's ruling. The prosecutor overstepped their bounds. Kings County District Attorney's Office, shame on you. But one of the areas where the judge extended some grace based on what was presented so far was, hey, well, I do see that the judge in the Youngblood case had concerns about these incorrect attributions, like these AI hallucinated citations. I don't see specifically that there was a finding of malice or intent. And it's just interesting to see that judge's order in the criminal case has been hailed in a public statement that Tyrone Blackburn posted as the judge deciding to stand with somebody and not allow these false claims against an advocate for survivor to go forward. And it was just merely someone was trying to come up with a ploy and falsely accuse them to silence their advocacy. And that really wasn't the ruling at all. Just to see the same case that the judge in the criminal case gave benefit of the doubt with his interpretation be brought up because there's been consequent abuses and unethical uses of case citations that seemingly don't exist. So anyway, we are back to seeing a case that, I guess, if you've tuned into one of these recent streams and you don't separately know Jakes v. Youngblood, I think Pam the Law Intellect, or Pam Esquire, depending on if you want to look at X or on YouTube, and I think I'm Not a Lawyer, but I believe they both did coverage on the filings in this case. I've only briefly mentioned it, but I believe that's where I was actually following along with what happened with Jakes v. Youngblood, if you're interested in going backwards on that case. But another Tyrone Blackburn hot mess. Because the court viewed Blackburn's conduct as a clear ethical violation of the highest order, the court struck Blackburn's motion to dismiss and reply memorandum of law from the record. The court then ordered Blackburn to show cause as to why he did not violate Rule 11. Not his first rodeo with Rule 11 problems. In Blackburn's memorandum of law in response to the court's order to show cause, he stated, so this is a quote from Blackburn, "I now understand that paraphrases, particularly those closely tracking the language from cases, must never be enclosed in quotation marks unless they accurately reflect the precise language of the cited source. In this instance, I failed to meet that standard." So he has explicitly written that you can't use quotation marks for paraphrase. I love Judge Willis. Judge Willis, where's Hal? Hal's in the chat. Hal is in the chat. And Adventure Erin would do this too. I just know it. I don't know any of Adventure Erin's legal writing, but I know how she recalls. She remembers things someone said one time and will call it out if they're like, oh, and now you're saying this. And I know Hal does it because I've seen Hal's legal writing. This is the exact type of gem what Judge Willis is going in here and weaving in, as in, oh, you're arguing this, but here you said you know exactly the opposite, and you said you're not going to do that again. This is the gem that somebody like Hal, somebody like Erin would weave in. So shout out to Judge Willis for going and pulling this and putting this in. The court in Jakes ultimately imposed a monetary sanction against Blackburn for $5,000. In addition to being sanctioned for the same conduct Blackburn has now exhibited with this court, he has been warned by multiple other courts against including inaccuracies and AI hallucinations in his briefs. On March 24th, 2025, in this district, Judge Otkin, it's always cited, this Otkin case always comes up, characterized filings by Blackburn as replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. And that is in one of the Diddy cases where Blackburn represents the plaintiff. On December 15th, 2025, in the District of New Jersey, the court sanctioned Blackburn for citing to non-existent cases created by AI hallucinations and failing to comply with court orders to provide information about the citation to the court. Another case where Blackburn's representing a plaintiff against Diddy. Oh, man. Blackburn's repeated inclusion of fabricated quotes in his filings demonstrates a pattern of complete disregard for his ethical obligations to make accurate representations to the court. He's been sanctioned repeatedly for his reliance on AI without verifying the quotations and citations before filing his submissions. Worse still, while he represented to a court last year that he understands words must never be enclosed in quotation marks unless they accurately reflect the precise language of the cited source, he brazenly minimizes and attempts to justify identical behavior here. When his fabricated quotes were discovered by counsel for Roc Nation in this case, he doubled down and made baseless accusations against opposing counsel. For those reasons, and all the reasons stated above, the motion to strike is granted, and the motion for sanctions will be considered unopposed. A separate order on the sanctions will follow. So we'll look forward to that. Additionally, this court made a referral. This is a previous referral that she's referring to. This court already made a referral of Blackburn to the Southern District of New York's Grievance Committee in its last order on sanctions, which was like right around the corner, like that just happened. Blackburn's citations to fabricated quotations and complete lack of acceptance of responsibility after previously being sanctioned for the same exact behavior is an outrageous breach of his ethical and professional obligations. Outrageous brief. Accordingly, this behavior will be incorporated in his referral to the grievance committee. And this language is important, not just because it's spicy to read, but when this Rule 11 motion for sanctions comes down, and Blackburn, I'm assuming, will appeal it, the judges have discretion in how they look at requests for Rule 11 sanctions. They have discretion for what they implement. But the idea of allowing a motion for sanctions to be considered unopposed is kind of an extreme remedy, extreme relief. It's relief that Roc Nation didn't exactly even request. They're like, oh, can you just ask him to file a compliant opposition? And so the judge is going to the extreme. And to use this language in her reasoning for why she's striking Blackburn's opposition, I think it's going to play a very strong role at the appellate level if Blackburn appeals the forthcoming order for sanctions. Oh, well, the reason for this somewhat extreme remedy is the extremely outrageous behavior. So, and it's going to loop into the referral to the grievance committee. So, how often does that happen where a referral to the grievance committee gets added to, supplemented, because they do the same thing again? In front of the same judge, in front of the same court that just told you not to do it. I don't know if I've ever seen that. Sometimes you'll see you've already been referred and now you're going to be referred again. Or you've done this so many times that I'm finally going to refer you, and all the previous sanctions I haven't referred you. I don't know if I've really read a case in recent times where we have a referral and we have to add more to it because you're doing the same thing a week later. So anyway, this was ordered today. Judge Jennifer E. Willis. Let me refresh the docket. We'll start looking at some of the letters. But let me refresh the docket and see. We're going to keep refreshing and see if we get the order on the sanctions. Maybe it won't be filed today. Maybe she'll want some time to file that. But this is a New York court. It's got just under 3 business hours. Maybe we'll see something come through. And then I don't see any updates. So let's do the letters. Or maybe we should take a look at the Rule 11 sanctions motion. We can at least look at the table of contents and get the headers for the argument. Let's see. I think I pulled up their latest sanctions request. I have so many tabs open, but I don't think I got this one. Go to June. Oh, maybe this popped up on the wrong docket. I don't know why, but sometimes with the companion cases, stuff is appearing on the opposite docket of where it should be. Let's try the other one. Yeah, okay, that's why I didn't see it. So this is actually on the Cartagena v. Dixon docket. So, but it's here. And this might explain why Judge Willis was referring to the other three parties as the defendant, even though for what Roc Nation's a part of, Roc Nation is only a defendant. They aren't a plaintiff in anything here. Let's see. Although I guess there's the defendants to the motion for sanctions. Let's do the memorandum of law. All right, that looks right. This is what we want. This is what we want. All right, and we're going to look at the table of contents just because we're not going to read the full thing, but this will give us a top-level summary. They're going to go through the history of when Blackburn filed this, why he named all the parties, why he asked to file a first amended complaint after failing entirely to respond to any of the motions to dismiss by any of the parties filed against the initial complaint. And then, of course, as we see in like every filing involving Tyrone Blackburn now, Spiral also included like the two Gardner and Jones v. Combs cases, Otkin, and I think Youngblood was also included here. But this block of cases of Tyrone Blackburn's other cases where he's gotten in trouble before were also included. And they're going to go through Rule 11. We'll read some of that so you're not just going with my version, my paraphrase of what it means, and then what they ask for. But in short, the specific Rule 11 issues that Roc Nation focuses on, because Rule 11 can cover a bunch of different things. It's really supposed to be a certification by an attorney that what they're filing, it's in good faith, it has some merit, it's not frivolous, you know, we're using causes of action that actually exist. We're not just like mad at somebody and filing a complaint that has no standing, no basis in any codified statute somewhere. And so the short version is Roc Nation says Mr. Blackburn and plaintiff violated Rule 11b1 by filing the original complaint for an improper purpose. So they say on its face the original complaint was frivolous, and that abandoning the RICO claim once they filed the first amended complaint was confirmation that they knew it wasn't filed for a proper purpose and they had to walk themselves back. Next, they say plaintiff and Mr. Blackburn violated Rule 11b1 by filing the first amended complaint. They say that plaintiff's TVPRA claim remains frivolous, and that plaintiff and Mr. Blackburn knowingly asserted baseless New York labor law claims because they're treating Terrence Dixon in these arguments. They're presuming that Terrence Dixon was ever employed by Roc Nation, and there was never an employee-employer relationship between the two parties. So New York labor law wouldn't apply because of that structure not being in place. Mr. Blackburn violated Rules 11b2 and b3 by failing to conduct a reasonable inquiry into the facts and law. Now this to me, this one's kind of big, but this to me is more specific, and it would be more on Mr. Blackburn. Like if a court finds that there's an issue with it's an improper purpose, maybe the attorney could be like, well, look, maybe my client had an improper purpose, but on face value, like what they told me checks out. and I did my diligence to try to check out what I could. There was some corroboration. So I didn't know that they had this ulterior motive in filing this. But when you get to something like C, and it says here, Blackburn specifically, he failed to conduct this reasonable inquiry. That would relate to why A would be an issue. They say that Mr. Blackburn failed to conduct an adequate pre-filing inquiry into the facts before asserting the TVPRA claims and the New York labor law related claims, and also that he failed to conduct an adequate pre-filing inquiry into the law. So two angles. You didn't check the law because structurally it doesn't apply, and you didn't check the basic facts. So, and then they argue that the conduct was bad faith. And let's get there. Let's read Rule 11. That way I'm just not hodgepodging it. Is this still the background? Yeah. Here we go. So let's learn about Rule 11. The fun stuff. The central purpose of Rule 11 is to deter baseless filings. That's from a case called Cooter and Gell. Rule 11b thus requires any attorney presenting a pleading, written motion, or other paper to the court to certify that to the best of their knowledge, information, and belief formed after a reasonable inquiry, the paper 1 is not being presented for any improper purpose, such as to harass, 2, that the claims, defenses, and other legal contentions are warranted by existing law, and 3, the factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And that's the language of the Federal Rules of Civil Procedure 11, Section B, 1 through 3. If all the attorney has is his client's assurance that facts exist or do not exist, when a reasonable inquiry would reveal otherwise, he has not satisfied his Rule 11 obligation. And that's case law coming from Saltz v. City of New York. Now, under 1927, Section 1927, any attorney who so multiplies the proceedings in any case, unreasonably and vexatiously, may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees. So this is the penalty. If you fail to do these things that you're supposed to be doing as an attorney, this is where we have instruction that the court can decide to award sanctions. And that's not the only avenue that a court can award sanctions. The court also has inherent power. So, a federal court may also exercise its inherent power to sanction a party or an attorney who's acted in bad faith, vexatiously, wantonly, or for oppressive reasons. The imposition of such sanctions serves the dual role of vindicating judicial authority and providing redress for litigants who bear the brunt of a party's bad faith acts. Now, the reason I think this is important, I feel like we're seeing the court under Judge Willis, not so much Judge Rochon, but under Judge Willis. The judge is using her discretion, in my opinion. She's not erring on the side of caution. She's not kicking down the can to the next time there's an issue on this very docket. She's not, I'll give a verbal warning. We just saw in the order we just looked at, I'm going to consider the motion for sanctions unopposed. I'm not even going to leave room for Blackburn to file a compliant opposition filing because his outrageous conduct, he's done this before, it's been a pattern, and I just wasted all of this time having to verify this stuff because he kept denying it and pointing the finger in the other direction. So she gave a basis for using her discretion. Oh man, let's catch up with the chat. Aaron says, let's define Rule 11 for Mr. Blackburn. You gotta give him the Bart Simpson chalkboard. Although apparently that doesn't matter because he's written things and not even, you know. EJF says, yeah, same here. We got some laugh faces. Is this all because I said the Cooter case? I can't believe we have Merriam-Webster definitions for quotation and quotation marks. We have a throwback to Christopher Boozy making an appearance in this case. And now we have case law where Cooter is in the kitchen. Oh my gosh. My goodness. Let's see. YSL Kel says he might as well give his license away. What's interesting is the attorney, Heather Palmer, who represented him in the criminal matter, is filing appearances to step in several of the other like civil cases where Blackburn is currently counsel of record. And in those notices of appearance, it's been stated that Blackburn is not withdrawing. Right, he's going to stay on those cases, and Heather Palmer, one of her, I don't know if it's a partner or another colleague of sorts, is stepping in as well. I forget her name. But it doesn't seem like he wants to step away. And then back in December, he was sending in letters for 4 different cases in Jersey saying he was going through too much and needed to step away from law for a little bit, but then insisted to Judge Rochon that wasn't going to impact his ability to be present and do his job for his client or for himself as a defendant in the Fat Joe cases here, let alone that was January of this year that he represented that to Judge Rochon. And then by the end of January, beginning of February, you guys are well aware of the rest and relaxation, the procedures, the narcotics regimen, all of that stuff that was going on. But he just insisted he was fine to keep going. So, Kel says, who wouldn't love an appeals court about your repeated AI situation? Miscellaneous productions, or projects, sorry, not productions, says seems like the judge could forego the sanctions and just hold him in contempt, jailing him for a week at a time. That might get a little more complicated on the jailing regard, but honestly, I feel like the financial sanctions are what might be the most serious to him. He's constantly asking for reconsideration on them and asking for payment plans, missing payments in the amount of like $300 and change by the deadline. And then he'll get them in at the last minute when there's going to be a more severe issue if he doesn't get them in. I don't know. It's just like a forever ongoing horse and pony show. For me, I think the referral to the grievance committee is important because he's said in other matters, even in his criminal case, he's pointed to, well, I don't have any action taken against me by any like grievance committees. My name is clear. And maybe this referral will go nowhere. But maybe it finally will, and then he can't rely any further in the future on, well, no grievance committee has ever said I did anything wrong. I've never been referred. Well, now you can't say that. Now you've got to say, there's never been an official finding by a grievance committee in this district, because maybe in the future there will be one in Southern District of New York. So now you can't say ever. You have to constrain the language down so that way you can say what you want to say without actually lying. So I think the grievance committee is what I want to see. And I just feel like I've been waiting to see that referral for months when it was Rochon presiding over most of the matters in this case. And then Willis comes in, reviews the record. And you heard me say earlier, like, I don't know if Tyrone Blackburn is making some of the statements he's making in what we read on this morning's stream with the hope, the optimistic hope, that Judge Willis isn't going to be familiar with or choose to familiarize herself with the prior proceedings. And I don't get why he would operate under that presumption, because in her first motion for her first order granting sanctions against Blackburn, she very clearly went and reviewed the standing matters of relevance, previous proceedings of relevance that she was not yet on board for. So if she did that, you should learn and think moving forward, well, I can't pull that rabbit out of a hat. That's not going to work. But it seems to me like that's exactly what he did this morning. Use these big words, say, you've been trying to tell the court these things and the court never heard you. And then the judge can go back on the record and see the same things that I remember happening previously where you were heard. And the judge made the findings that Judge Rochon made the findings that she made accordingly then. So, and here we just saw with the order we read a few minutes ago. She went and reviewed 1740 citations. She went and looked up the dictionary definition. Like, she's not just willy-nilly signing off an order with no reasoning, with no examination of the record or anything else that might be relevant. And yet it seems like Tyrone Blackburn's just crossing his fingers and hoping for someone, oh, you seem like you have hurt feelings and I don't want to be mean, so I'm going to give you whatever you're asking here. And I hate when judges do work that way. Some judges do work that way. And maybe that's fine for for everybody has a bad day. Fine. Let's see if we can get past it, move on to the merits of the case. But when it's repeated, I hate to see a judge that's just don't do that again, and then doesn't do anything. Yeah, so Destined to Be says she has 0 time for games. I am loving Judge Willis. And super love here, Sheriff Chuck turning the chat green, not just once, but twice. So big thank you here to Sheriff Chuck. The first 5 is for the definition of quote, and the second 5 is for the definition of quotation mark. I'm never going to use a quotation mark the same. And now, when I read things out loud, maybe not here if we know we're reading case law, but when we're reading an order and the judge is quoting something that an attorney said, for the listeners, I like to state out loud, this says, quote, and then I read the quote, and I say end quote. Unless there's one word in between, and then it continues. I don't always say end quote. Maybe I should. Now, whenever I say that, I'm going to think of this. I'm going to think of today's order. And I'm going to want to stop and tell the chat, do you guys know what quote means? Do you know what quotation marks are for? What I'm about to read to you is not a paraphrase, or it shouldn't be. It should be verbatim. So now my life as I know it is changed forever anytime I read a quote on stream. Again, his big thank you to Sheriff Chuck here, holding it down, supporting the show, bringing us back for today's round 2. Also, he says he needs to step away from law for a little bit, if a little bit means eternity. You put that in quotes. Oh my goodness. I agree. And I really feel bad for he really does have a lot of cases and a lot of clients, and he is a solo practitioner. So it's not if take Alex Sparrow, if he was up, can't do this one anymore, I'm in trouble. They've got a whole firm. Someone could tag team in. Other people are probably already working on cases. It's not just Alex Sparrow and he's the one signing his name on something. He's got people that help him do research, do his emails. Tyrone Blackburn really has a lot of cases. I don't just make fun of that clip where he's relying on that so many cases excuse for not remembering if Terrence Dixon's his client. At a deposition about the case where Terrence Dixon's his client and he's a co-defendant. It's just, if he steps away, and some of these cases have already been going on for 2-3 years. There are cases in the Southern District of New York, the Diddy cases, where a lot of them have been stayed because there is appellate happenings relating to the New York Survivors Act. I forget the acronym for it. NYDVMA or something like that. DVAS, something like that. I forget the acronym. But there is appellate litigation about the statute of limitations, when something can revive it. And so a lot of those cases were already stayed for quite some time. So the parties in those cases, his clients, and in the cases that he happens to be representing somebody in, it's already years down the drain. And can you imagine if he steps away from law or gets this severe punishment where he ultimately has a suspension of his license or loses his license or just decides to quit? All of those clients who've already been sitting waiting for any number of reasons. It's going to be more years that need to be tacked on. Oh my gosh. C. Mish says, in the wise words of St. Woody of YSL, he fied. Oh my goodness. I think that really, that happened in the Diddy case. I forget the client's name, during the Diddy trial. Bianca? I don't know why I'm thinking Bianca. Something with a B in the name, maybe? But she testified during the Diddy trial that she fired Tyrone Blackburn. And then there was a woman who Tyrone Blackburn dated, the woman's best friend, because she knew, oh, your best friend's dating a lawyer, ended up retaining Tyrone Blackburn for some matter, but wanted to fire him because stuff wasn't, I don't know, like it just wasn't a good fit. Some stuff wasn't getting done. But after that firing, there was like all of these issues between the two. And the woman, the friend, filed a police report over like harassment because Tyrone Blackburn wouldn't leave her alone. And he was like sending her texts about her nether region having smells and calling her sexually promiscuous, things of that nature. So it doesn't seem like when someone does try to fire him, he has an appropriate approach to it. I don't know. And I said on today's stream, it really makes me feel bad that when I see a lawsuit come through and he's the person representing them, I can't apply the. You hope that when you see a complaint filed, my basis is, hey, this is only their side at this point in time. This is very early in the litigation, but at least it made it this far. Somebody signing their name off on the pleading. An attorney's putting their name, ink on the paper, to put this complaint through. But when I see something come through with Tyrone Blackburn as the attorney of record, I can't even at least give it that additional step like, hey, someone's willing to sign their name on it. Because I feel like he'll sign his name to anything. And I really don't mean that to disparage like the underlying client, because every case is going to be different. But that's how I feel when I see him come through on a filing. So anyway, for these short reasons, this is all the way back on June 1st. Roc Nation through Alex Spiro, and I don't know if anyone else signed off on this. Okay, we have Joanna Manillo as well. So there we go. Yeah, and she did one of the recent letters. So we'll do Spiro and Manillo. Maybe it's Manillo. So they filed this request. They sent this in on June 1st. They're like, look, we want these sanctions, these Rule 11 sanctions. Like, this stuff is... We want terminating sanctions, so we want this dismissal. We want attorney's fees. Blackburn admitted nearly a year ago that neither he nor his client have a valid basis to include Roc Nation in this litigation. Now, if you're wondering what that's referring to, Tyrone Blackburn, after filing Terrence Dixon's complaint. After the complaint was filed alleging civil RICO among all the parties, including Roc Nation, as well as several other claims against Roc Nation, Blackburn sends email to Roc Nation's counsel. Like, we know you didn't know what Fat Joe was doing. Like, why would you say that? Why would you say that? And it was after the complaint was filed. And in a more recent filing, or in the opposition, that 65-page opposition, maybe we should just find that. Because when I tell you I was reading Tyrone Blackburn's opposition, and I felt gaslit, and I was sitting there, I was spending like an hour going through the claims. Where is it? Where is Blackburn's opposition? Here. First, there was an issue with the emails. Let's see if I can pull it up with the word complaint. No. Maybe the word before. Pre-litigation. Let's try pre-litigation. Okay, I think let's go here. Section C. I was sitting here reading this to myself this weekend, and I was like, does he really have a valid claim here? Am I misremembering the way things happened? This is Blackburn's opposition that is now stricken from the record. But even outside the citations, like if we take AI out of it, there are other issues. Because I wasn't even thinking in terms of AI. I had the gut feeling, but I told myself, like, there's no way he would be that stupid and do it again. If there are AI, I'm sure the other attorneys were going to see them call it out, and sure enough, they did. But there were other issues. So one of the arguments, when you plan as a party to file, you're requesting sanctions because you're alleging some violation of Rule 11. you're supposed to file what's called like a safe harbor letter or notice. And Tyrone Blackburn's position was that no safe harbor was filed, that if one was filed, it was only filed in relation to the initial complaint and not a new one following the filing of the first amended complaint. And then he went on to say, well, the email shouldn't be considered notice, which means that you did actually get notice of a renewal, that Roc Nation would again be moving for Rule 11 sanctions. And like, which are you arguing? You're saying you didn't get notice, then you're saying the notice you got wasn't through the proper forum. So maybe you're treating it like it wasn't notice. And then I saw this response got into another issue that confused me. And it was this idea that a pre-litigation negotiation email cannot defeat the colorability of a pleaded claim or supply subjective bad faith. And I'm thinking, like, what email is he talking about? Because the only email I remember Roc Nation relying on was this series of quotes back and forth. It was like a few statements, few quotations pulled out of the email, hopefully exact quotations. Let's see, email. And it was included in the first motion for sanctions for the initial complaint. And then I think it was reincorporated in this June 1st one. Let's see, email. I don't remember how to find it on the docket. But Spyro, maybe it was like judicial notice. Maybe he asked the court to take notice. Maybe it was in his first motion for sanctions. Sorry, give me a second, because I think the quotes are worth looking at, especially if you haven't heard them in a while, or if you don't remember this email to Roc Nation in the very early days. Let's see. July 22nd, 2025. It opened right to this page. Okay, so this URL, maybe it kept my history from this weekend, because when I saw that this weekend reading it, I'm like, pre-litigation emails, these are the only things I'm familiar with. This would have been after. This would have been after, not pre-litigation, because once you file a complaint, you are litigating. You've initiated litigation. So I went and checked. And sure enough, if we take Roc Nation at face value here, this motion, this request for sanctions, this first one for the initial complaint, back in July of 2025, they start off by talking about these emails and saying, 2 business days after plaintiff filed the complaint, Roc Nation moved to dismiss it, not least because it fails to allege any facts that even remotely suggest Roc Nation was complicit in TVPRA or RICO violations, just hours after Roc Nation filed its motion. So they're not going to file a response to something that doesn't yet exist, right? The complaint, the litigation has to be initiated for someone to be moving to dismiss the complaint. And then after that response, after that motion to dismiss is filed, after that, Mr. Blackburn sends these emails that Blackburn is now characterizing in the opposition to the latest motion for sanctions as pre-litigation emails. And I couldn't believe what I was reading. I swore I must be mistaken. Like, there's no way you could mess that up, especially when you are the sender of the email correspondence and it's already been called out specifically in this motion for, isn't that funny? We move to dismiss something. Like, you're going to read the motion to dismiss and you see that somebody's arguing, you just sent us these emails. So now we want sanctions. So there's no way, in my opinion, that Blackburn could be mistaken and be characterizing these emails as pre-litigation emails. So that's another layer upon layer of issues outside of just using AI citations in his recent opposition that is now stricken. But anyway, these are some of the quotes from the And it's called out specifically. They say specifically, and despite signing a complaint mere days earlier that accused Roc Nation of participating in human trafficking and racketeering schemes, Mr. Blackburn stated, these are the email quotations, my client has no animosity towards Roc Nation. We think it's evident from the evidence that your client may have been defrauded by Mr. Cartagena as well. I'm certain your client may have been caught off guard by Mr. Cartagena's lack of transparency and honesty. I'm sure Roc Nation did not and would not have approved of Mr. Cartagena sending threats via Instagram. Mr. Cartagena, and then it's in quotes, hid money from Roc Nation by accepting cash payments for performances, which I know is a direct violation of his contract with Roc Nation. There are other unpleaded acts of violence that, quote, I would assume your client knew nothing about, end of that quote. And I'm happy to see that your client was smart enough to distance themselves from the remaining defendants. And then they said Mr. Blackburn reiterated similar sentiments in the press, telling Billboard that he was pleased to see Roc Nation distancing itself from Mr. Cartagena's enterprise. Like, so again, that was from the first, like July 22nd, 2025 motion for sanctions that Roc Nation filed in response to the first complaint that Terrence Dixon filed. But then in the last week and a half, we have Blackburn arguing that, oh, you can't hold those emails against me. It was a pre-litigation negotiation email. Like, it just had me scratching my head. I don't know. If I look confused up here, I was legitimately confused reading this. Hells, right? He's familiar with his own pre-litigation threats. You would think. You would think. You would think. Oh my goodness. Lauren. So anyway, he tried to argue in this that beyond its substantive, and I don't know if it's him writing this whole thing could be written by an entity and not a human. Beyond its substantive incompatibility with Section 1595A's constructive knowledge standard, the Blackburn email cannot do the Rule 11 work Roc Nation demands of it for an independent structural reason. Rule 11 tests the pleading, not counsel's pre-litigation negotiation correspondence. I mean, would you not argue that these are statements about what's in the pleading? Like, I just don't get it. I don't get it. This makes me feel like I don't understand what I feel like I've learned about law from following cases. It confuses me that much that I question myself. And yet I know it's just BS. So it just takes me, I have to pause. I have to pause and think through it before I let myself be bamboozled. They say the Rule 11 inquiry is whether the operative pleading is objectively unreasonable at the moment of filing. And I think those quotes from the email go a long way to showing that at the moment of filing, not only for Terrence Dixon, but also the attorney, Tyrone Blackburn, who filed the pleading on their client's behalf, that it was objectively unreasonable to include Roc Nation as a party, at least for the stated causes of action. Maybe there was something else, but for the stated causes of action that involved Roc Nation, I think those emails go a very long way to showing that the pleading was objectively unreasonable at the moment it was filed. I don't think we need hindsight bias. And whether it is so utterly lacking in support, that's in quotes, that it has, quote, absolutely no chance of success. My goodness. It goes on to say whether counsel used candid or exploratory language in a private negotiation email months before filing. Now we're months. Now it's months before filing. Has no bearing on whether the First Amendment complaint. Oh, this is dirty. So he's saying it doesn't matter. You can't just say something's pre-litigation because you amended your complaint. That doesn't mean the initial litigation wasn't opened. Is that what he's doing? He's acting like all the litigation goes away just because he decided to file a first amended complaint that Judge Rochon graciously, like, another judge could have denied him the leave because it was like months where the motions to dismiss went unanswered and no request for additional time was filed. But is that what he's doing? He's acting like all the other litigation, the rest of the docket doesn't exist because we filed an amended complaint. So those emails must now be pre-litigation emails. It's called an amended complaint for a reason anyway. It's not the first ever complaint after the initial one goes out of existence. That's crazy. A for creativity, I guess. Anyway, he argues that this pre-negotiation email months before filing has no bearing on whether the first amended complaint's TV puree allegations, judge just pleaded, cross that threshold. They do. Like, then the next sentence says Rule 11 does not deputize opposing counsel to comb pre-suit correspondence. The lawsuit was already filed for turns of phrase that might in isolation be marshaled against a properly pleaded claim. To the contrary, I hope that this issue is addressed. I hope that Willis goes beyond just the AI issues and addresses these representations. It would take her going back and looking at the record to see when this email occurred. But to be fair, I mean, if she goes back to the initial motion for sanctions, Roc Nation makes it very easy because they attach the email correspondence. So you can see the date. Hey, Tiff, I agree. I'm going to get you could be my placeholder on screen. You can say it for me. Oh my gosh. I've been laughing a lot this stream. I have been laughing a whole lot. Yeah, surprise, surprise, he's at it again. It's an excuse for us to get together. Good to see you, Lakia. Oh my goodness. Anyway, so this was a lot, and this is where we're getting these hallucinated citations. This is the now stricken opposition. Following that opposition, we have a series of 3 letters. And what's pretty common, and there's been a lot of them in this case, if you don't want to spell out a full motion, and here the judges request it, like their individual rules of court say, look, like, to try to keep things moving smoothly, keep things going. If there's an issue, try to communicate with each other. If you need to refer to me, if you need to contact the court, if you need a little bit of refereeing, but it's not really a full motion, send a letter to the court. So we'll get a lot of these. We've had a lot of these in the case. And I want to point out this is addressed to Judge Rochon for the purpose of this first filing, this letter on July 1st from Roc Nation. Well, it's from everybody. So we get this like omnibus motion to dismiss. So this letter is on behalf of all the defendants who joined in that omnibus motion to dismiss many months ago. And then after they filed their omnibus motion to dismiss, it went unopposed. The deadline passed, and Judge Rochon granted leave when Blackburn filed a late request to file a first amended complaint. And then when that was opposed, we get in these letters. They say, we write on behalf of defendants Fat Joe, Slate Inc., Sneaker Addict Touring, Roc Nation, Peter Torres, that's Pistol Pete, Richard Jaspitra, I can never say his name, Eric Morera, regarding the defendant's motion to dismiss plaintiff Terrence Dixon's amended complaint. So after the first extension of grace, they're late. Terrence Dixon gets to file an amended complaint, even after just inexplicably not responding to any of the motions to dismiss the first complaint. Judge gives them permission, and guess what happens again? They're late again. They are late again. So the court had ordered, okay, I'm going to give you leave to file this amended complaint. I'm going to give the defendants time to respond, file their motions to dismiss your newly amended complaint. And then you've got to oppose their motions to dismiss by June 30th. And here, this letter is all of these parties pointing out that June 30th has come and gone, and Dixon has filed nothing. He didn't oppose the motions. He didn't seek an extension of time. He didn't move to amend. And the court should deem the motions unopposed and grant them for the reasons stated in defendants' moving briefs. They point out that this is not the first time plaintiff neglected to respond to dispositive motions. Defendants Cartagena, Slate, all of them, filed motions to dismiss on November 10th, 2025. And Roc Nation, I think, filed before this. I think they filed a separate one more quickly. Plaintiff missed the January 31st opposition deadline. He ignored defendant's letter alerting the court to that failure. And only after 40 days of silence did plaintiff move to amend. And even then, the court cautioned him. And again, this was Judge Rochon still. This is the warnings I'm always talking about. There's always warnings from Rochon. Dixon is warned, ... that given his inexplicable delay in making this request to amend, and the fact that he has had ample time to consider the arguments in the present motions to dismiss, further amendment after renewed motions to dismiss are decided will likely not be permitted to address deficiencies that have already been highlighted in the present motions. On Monday, June 29th, and if this seems familiar, it's because we read this letter for this paragraph before. We were holding off on all of this like back and forth, the motion to dismiss and this Rule 11 motion for sanctions. But we did look at this letter because this is where we first heard, according to the representations of counsel preparing this letter, that they got notice from Tyrone Blackburn on June 29th that he will be filing a letter with the court on the morning of Tuesday, June 30th, advising of my withdrawal as counsel for Mr. Dixon in both matters. At the time they wrote this, July 1st, Mr. Blackburn never filed the promised letter with the court, never sought an extension of the deadline to respond to the motions, and remains counsel of record until relieved by the court. And now remember, there's the whole ongoing order to show cause saga going on now that he's filed the motion to withdraw. And there is a public listen line for that. So tune in July 21st. If you go to the stream we did this morning, I put up the number. I'll do a community post and share the number on the morning of that hearing. They say that accordingly, the defendants request that the court deem the motions unopposed and dismiss this case in its entirety for the reasons stated in defendants' moving briefs. Respectfully submitted, this is Fat Joe's team. So this is from Jordan Sieve and Takapina, who have their own firms. Then, on July 3rd, we're going to be back to Roc Nation. On July 3rd, also addressed to Judge Rochon. And the request we just read from Fat Joe, Judge Rochon denied that. We talked about those docket updates this morning. It was the quick memorandum updates. Let's see, are they on this docket? Yeah, it was this set of quick dockets. Yeah, they get that he's able to file. This is all from Judge Rochon in response to what we just read. Terrence Dixon, they got the leave to file their response to the motion to dismiss late. The request to deny the permission to file and then to also dismiss as unopposed was denied. That we just saw that request that we just saw from the omnibus parties. And then what was this? Yeah, to dismiss the case entirely denied. So this is Judge Rochon denying the relief requested in the letter we just read. Back to Roc Nation, who, although they're still addressing this letter we're going to read to Judge Rochon, the court's going to file a memo to all the parties like, hey, this is transferred to Willis. Go to Willis. Don't go to Rochon. We write on behalf of defendant Roc Nation, LLC, concerning plaintiff Terrence Dixon's opposition to Roc Nation's June 1st Rule 11 motion for sanctions. Dixon's opposition's untimely. It exceeds this court's word limit and contains what appears to be AI hallucinated citation. So this is the letter, this is the phrase that we saw Judge Willis cite in the order we read at the beginning of the stream. Roc Nation respectfully requests that the court strike Dixon's July 1st opposition. 2, direct plaintiff to file a compliant opposition no later than July 7th at 5 p.m. Eastern Time. And 3, grant a corresponding extension of Roc Nation's deadline to file a reply until July 28th, 2026. So that's what they were asking. If plaintiff fails to file a corrected brief by the new deadline or files another, non-compliant brief, Roc Nation respectfully requests that the court deem its Rule 11 motion unopposed. So I didn't see an order come in that made this step happen. That's why I'm saying Judge Willis went from here to here. Oh, it's not letting me highlight the way I want. I just wanted to draw an arrow. But pretend there's an arrow going from step 1 to this if we fail to do 2 and 3, we jump to this remedy. Court didn't order the intermediary possible solution. First, on June 2nd, the court entered a scheduling order directing Dixon to file any opposition to Roc Nation's motion no later than June 30th. Dixon did not do so. He also did not seek leave to extend the June 30th deadline. His opposition, filed on July 1st, is therefore untimely. In addition, the opposition is approximately 11,043 words, which exceeds the 8,750 word limit under Rule 7.1c of the local rules. And if you're going to go beyond that, you have to ask the court for leave. You have to get permission to do so. And they didn't even do that. And let's see. And it's also against the court's individual rules of practice. And it does not contain a certificate of compliance with the word count limitation. Well, I wonder why. Second, the opposition contains numerous citations that appear to be AI hallucinations. Courts in the circuit regularly impose sanctions where a party relies on AI hallucinated citations. So they give the case of Park v. Kim, Second Circuit, 2024, issuing sanctions and explaining that it is required that attorneys read and thereby confirm the existence and validity of the legal authorities on which they rely. They cite Mata v. Avianca. It's from the Southern District of New York from 2023, issuing sanctions under the inherent authority of the court for submission of quote, fake citations. I give a bunch of cases here. Though the decisions, which I guess these must be some of the ones that Blackburn's going to be like, no, those are fake quotes. Though the decisions plaintiff cites appear to be real cases, the quotations he attributes to those decisions are fabrications, and the propositions for which he cites them find no support in the decisions themselves. Now, you see how precise this wording is? So we already know that Judge Willis, she said, I went and I looked through these myself. In Judge Willis's order, she's like, yeah, they might be real cases, but you're using quotations to quote things that aren't quotable. It's not direct text. What are you doing? Let me define quotations for you. And here, Roc Nation isn't overextending their hand to try to claim more than what's happening. They don't try to say like, oh, you're making things up. They state very precisely that the cases that are cited appear to be real cases, but the quotations, the attributions don't appear to be real. They seem fabricated. They seem hallucinated. For example, which to me, that's a good faith criticism. That means you looked. For example, plaintiff repeatedly relies on purported quotations from Star Mark Management, the Kunchun Hengki Soy and Sauce Factory, including 1, strict compliance with Rule 11C2 is required. So they're going to pull some of the quotes, I guess. 2, that the safe harbor rule must be strictly enforced because, quote, the purpose of the safe harbor is to give the offending party a meaningful opportunity to correct the alleged violation. And these are the quotes I was reading, and I was like, dang, is he gonna like pull off a technicality here? It's got to be strictly enforced. That's very helpful for Blackburn's argument. But apparently these aren't real quotes. How do you think about that? 3, another one. The safe harbor letter must be sufficient, specific to give the party notice of the claim, contention, allegation, or denial that is challenged. And then 4, other references to strict compliance and strict enforcement of the safe harbor rule. None of these quotations can be found in Star Mark. I was bamboozled by each of these quotations. They got me. They got me. They got me. Similarly, plaintiff misquotes and misrepresents the Supreme Court's opinion in Cooter. There is Cooter and Gel. He claims that Cooter and Gell said, 1, the policies underlying Rule 11 encourage litigants to abandon claims or defenses. This got me too. The Cooter case got me. They falsely quoted Cooter. Because he used this in his argument relating to when I trimmed the RICO claim out of this complaint, it wasn't an acknowledgement that it was brought improperly in the first place. It was strategic pruning. And this case encourages it. Cooter encourages me to do some pruning. And I read these quotes and I'm like, dang, that is helpful for him. But alas, are they real quotes? These quotes that I thought were very helpful to his argument? And I was astonished to see so. This case, according to Blackburn's representations, said that that Rule 11 exists to encourage litigants to abandon claims or defenses and to promote the correction of pleadings. Cooter and Gell, maybe it's Gell, contains none of these quotations. So there I go. I was bamboozled. On the contrary, the court reached the opposite conclusion. Oh my gosh. So Cooter and Gell said the opposite. Rule 11 is aimed at curbing abuses of the judicial system. Quote, a voluntary dismissal does not eliminate the Rule 11 violation. They bolded. So in their filing, Roc Nation, I think, is bolding. Yeah, that says emphasis added. Their bolding does not. Oh my goodness. That's hilarious. That's hilarious. Reading all of this on stream, if we didn't see the order first, I don't think it would have been, I would have been very confused because there would be no way reading the motions with a reading on stream unless we stopped and hit paused and looked up every case ourselves. We pulled an Ali Mata. Would I have like appreciated what was going on? It would have just been maybe my gut feeling, like, I don't know if I can trust these citations, but why would he do that again? You'd hear me say to you guys in real time what I said I was thinking to myself this weekend. But now that we know, at least if we take the judge, her word, that she went and looked up these citations, and now we're reading Roc Nation's response here, I'm very much inclined to agree that Roc Nation looked at this case and that the quotation that they're providing here is likely the correct quotation that shows the opposite holding of what Blackburn represented. Not even represented, but quoted it to say. So they say this case says that a voluntary dismissal does not eliminate the Rule 11 violation. And if a litigant could purge his violation of Rule 11 merely by taking a dismissal, he would lose all incentive to stop, think, and investigate more fully before serving and filing papers. Oh, I love to see that. Because that's what I was thinking. I'm like, if there's such strong case law like this sucks, because how would Tyrone Blackburn ever get in trouble if he's filing something frivolous? Because the case law seems very strong to protect it based on the quotes that he provided, which don't exist. They said this problem pervades plaintiff's opposition. On 3 instances, plaintiff erroneously attributes the same quotation, that Rule 11, quote, applies only to assertions contained in papers filed with or submitted to the court, end quote. And they cite this to Ted Lapidus from the Second Circuit in 1997. In addition to the above, Roc Nation has identified at least, right? So this wasn't an exhaustive list. They identified at least 17 other quotations in plaintiff's opposition that do not appear in the cited authority. And I love a table. I love to see a good table. So first column, they're giving you the case cite. Then they're going to give you the attributed quote. And then they're going to tell you where to go find where we're supposed to be pointing to within that case. So a serious matter. Merely because a claim proves unsuccessful does not mean it was frivolous when filed. These are all the quotes that apparently do not exist, or at least 7 of them, not all, 17 of them, not all of them. It is patently clear that a claim has absolutely no chance of success. Another quote that says absolutely no chance of success. A shifting standard would sanction lawyers for making avoidable mistakes. This quote we just included utterly lacking, and there is no phrase that matches that in this case. The plain language of the statute limits its application to attorneys or others admitted to conduct cases. Mere negligence, however substantial, will not suffice. Sanctions must be based on the record before the court, not on collateral impressions. Fees for the specific misconduct. Excess proceedings caused by counsel's conduct. This is a lot of fake quotes. An extraordinary remedy. Because inherent powers are shielded from direct democratic controls, they must be exercised with restraint and discretion. So this seems like in Blackburn's opposition, he started to argue that if you find all these things, it would be an extreme sanction to not grant us leave and to not let us oppose Rule 11 sanctions and all of that. This one isn't just a quote. This one says the phrases and procedural prerequisite is in quotes. And then in quotes is also Rule 11 sanctions could be imposed. More fake quotes. A warning letter as opposed to the service of a proposed motion for sanctions does not trigger the safe harbor period. And I wonder if these ellipses were like part of the quote or they're doing that for the table. Rule 11 requires that a copy of the actual motion be served on opposing counsel. Oh, I fell for this citation too. I was like, dang, so the email's not going to be enough? And the reason the email thing is interesting is because Tyrone Blackburn ping-pongs back and forth. He'll say he waived service and just email him, but then he won't respond to emails, and he'll say he didn't get something or he was too busy. But then he'll also say that email service isn't sufficient for certain matters. And it's actually something that became a critical part of where the prosecution, the Kings County DA's office, the ASA that was prosecuting the criminal case with the process server against Tyrone Blackburn, during the presentation to the grand jury, went too deep, asking too many questions about like, well, as a lawyer, you know that you should serve people in person, right? But it became a whole thing, and it's like, depending on which way Tyrone Blackburn wants the wind to blow, he's going to say one thing or another and tell you, well, the wind's actually blowing this way. More quotes. Sophisticated party with red flags. Huh? Clear evidence is in quotes here, and then subjective bad faith is in quotes. A pleader may assert contradictory statements of fact only when legitimately in doubt about the facts in question. What? A worker may be jointly employed by two entities, even where one entity has more control than the other. So this must be in relation to the NYLL claims. You have subjective bad faith in quotes again. Then bad faith showing, quote, requires more than mere negligence, end quote. And then we have legitimate goals. That's the end of the table. That was some of the stuff that they found. So they're saying at least 17. Hot mess. Hot mess. I love a table. And what I love a table, and I think Tyrone Blackburn does one back. One of my favorite things with the Zachary Adams post-conviction proceedings, Zach Adams' team put together a table to point out, I think they used two tables. One was more of like a timeline, and then another was to point out like issues, contradictions to testimony from the two key witnesses, Victor and Jason Autry, Mr. Autry. And I loved seeing the tables because it makes it very easy to see what the specific language is or the event and where you can go to find that in a citation. It's easier to follow than it being lumped in a paragraph. And what I thought was funny is as soon as Zach Adams' team started using tables, the state in their response also did a table. And I don't think their table was as good or informative or like really like nailed the punch and contradicted the problems that the timeline itself spelled out. But I love a good table. It makes it easy to illustrate like that is a lot of fake quotes. It'd be different if we couldn't make a table because there was only one instance. Might we have a different ruling from the judge? I think so. Because you could accidentally misquote and just total mistake. You could think you verified something, like when you miss a typo. You could try to verify and proofread something, but you could still reasonably miss a typo. But when you have a whole table, did you verify? Did you do your job before submitting these representations to the court? If we can put a whole table together, the strength of that excuse diminishes when there's a full table. So back to the letter here, Mr. Blackburn's citations to illusory authority are improper, as Mr. Blackburn himself conceded earlier this year. Oh, I was gonna say, is this where Willis got? No, this is from Nantongo v. Nationwide Mortgage Bankers. That is another saga that we still have on the back burner to do a stream on. It's there's a pause on the filings right now, I think, because there's a collateral case. But this one's been another mess that we mentioned previously, where Tyrone Blackburn's former colleague, they worked to represent Nantongo together as well as a third attorney that I don't remember the name of right now. But this other attorney, Fred Charles, is the same attorney that Blackburn was like, oh, I was using his LexisNexis account, after Blackburn blamed LexisNexis for being the reason that there were misattributed quotes when he got in trouble earlier this year in this case and in another case. In both cases, he blamed LexisNexis. And then LexisNexis filed, they wanted the court to take judicial notice, let the court know, hey, Tyrone Blackburn and his law firm name, neither of them are subscribers in our system. So then Blackburn came along and was like, oh, I was using Fred Charles' account, so they wouldn't have been able to find me in their system. But I was using Fred Charles' account, which goes outside the terms of service of LexisNexis. You're not supposed to share your accounts or access it through someone else's. But that was his excuse. He pointed to this guy, Fred Charles, and that was the reason he was having these issues with fake citations in 2025. Well, in this Nantongo and collateral case issue, Fred Charles and Tyrone Blackburn, they're fighting. Fred Charles says that Tyrone Blackburn sent him like weird and unhinged text messages. Tyrone Blackburn says that Fred Charles defrauded and deceived Nantongo when he represented her as well. The same case they were representing her in a suit against her former employer. The case settled, and based on the word of Tyrone Blackburn, there is an affidavit signed by Nantongo, but there's also a reference to like stuff she said on voicemail. And Fred Charles is like, hey, I haven't actually spoken to Nantongo. As far as I know, the only existence of anything supposedly being said or claimed by Nantongo in this case is coming through Blackburn himself. So Fred Charles' position seems to be that Tyrone Blackburn may potentially be making up these claims that Nantongo is raising a fraud issue with just Fred Charles and the third attorney that I forget his name. That they haven't heard from Nantongo themselves. And that they've been getting these unhinged messages from Tyrone Blackburn to the point where they had to block Tyrone Blackburn. And Blackburn's position is that they forged, that even though he was co-counsel at the time, that the other counsel forged Nantongo's signature on the settlement agreement. And Nantongo, even though that this was closed out like 2-3 years ago, now is saying, hey, I never signed off on that. They forged my signature. I didn't know this was happening. So there's a whole mess. When you see this name, Nantongo v. Nationwide Mortgage Bankers, there is a whole nother saga sitting there under the ice. Even the ice. So, oh my gosh. So another stream on the back burner, with that one coming eventually. That's over in the Eastern District of New York. So but here Roc Nation is quoting this snippet from a filing that Blackburn filed in Nantongo, where he's like, it's a breach of duty of candor to the court. Attorneys should never send in fabricated citations. This idea that I know better. Here's me saying I know better. So Roc Nation's like, look, he's saying he knows better. But unfortunately, it appears that Mr. Blackburn has not been dissuaded by court orders or the threat of sanction from filing unchecked AI-generated submissions with false legal citations. And then they quote that from Flycatcher Corporation v. Affable Avenue. Those are fun names. Entering default judgment under inherent authority where counsel's AI misuse resulted in erroneous citations. This misconduct not only betrays his duty to the court, but it imposes unfair and unreasonable burdens on parties like Roc Nation, which is forced to chase ghosts in the case law and do what Mr. Blackburn should have done in the first place, the routine task of cite-checking his own brief. And they cite Benjamin v. Costco. Dang, Costco got sued. Given the unusual and excessive volume of fabricated authority in plaintiff's opposition, Roc Nation should not be required to expend further resources or costs responding to it. To ensure that the court has an adequate basis on which to decide Roc Nation's pending Rule 11 motion, Roc Nation respectfully requests that the court 1. Strike plaintiff's opposition, 2. Order the plaintiff to file a compliant brief no later than July 7th, 2026, and 3. Extend Roc Nation's deadline to file a reply until July 28th. And again, I never saw an order for this to occur. All right, we never actually get the court to order, like, fix your brief. Roc Nation further requests that if plaintiff fails to meet this deadline or files another non-compliant brief, that the court deem its Rule 11 motion unopposed. So that was submitted by Miss Manillo. Where is Tyrone Blackburn's letter? So following this letter from Roc Nation, I think we're moving to July 7th. Let me see. That's Fat Joe's letter. Oh, don't forget on July 7th is also when we had, it wasn't the memorandum of law yet, but we had the quick notice of a motion to withdraw filed by Tyrone Blackburn. So we get that on the 7th as well. I have the response. Maybe I closed the tab on accident with the July 7th letter. Yeah, I closed it. Okay, so this is, here we go. Here's his letter. Here's his letter where he goes, "Nuh-uh, you did it." And it's still to Judge Rochon. July 7th, "Dear Judge Rochon, we write on behalf of Terrence Dixon in response to Roc Nation's July 3rd letter concerning plaintiff's opposition to Roc Nation's Rule 11 motion. The serious accusation at the center of it is a serious accusation. The serious accusation at the center of Roc Nation's letter, that plaintiff's opposition rests on AI hallucinated citations, is not accurate, and plaintiff respectfully asks this court not to accept it. Every decision cited in the opposition is a real, published, binding authority. Each was cited for a proposition it actually holds." And as Roc Nation itself concedes, the decisions plaintiff cites appear to be real cases. Yeah, they conceded that. But it started as like, how did they word it? Although plaintiff cites actual cases, the holdings and the quotes aren't, like something like that. So it's not really quite the concession. The cases at issue in Roc Nation's letter, among them Lawrence, Gall, Lancaster, Kiobel, Story, Sussman, Olivieri, Chambers, Iman, it's a lot. Walters, Kluwer, Henry, and Barfield, are the settled Second Circuit and Southern District authorities that govern this motion, and each supports the proposition for which plaintiff cited it. This is the opposite of the Mata v. Avianco scenario, where counsel cited cases that did not exist. And is set forth, all right, so he's giving one example because Roc Nation relied on a case that dealt with the case captions themselves not actually existing. The cases themselves don't exist. They're going to focus in on that one citation. And as set forth in section 3 below, when Roc Nation's own motion briefs are audited, as they did to my brief, roughly 1/3 of Roc Nation's quotations in their sanctions brief are flagged as incorrect, including a bad faith quotation misattributed to a United States Supreme Court decision, and over 80 of the 117 quotations in their motion to dismiss brief are flagged as incorrect. The premise of Roc Nation's letter thus condemns its own motion in equal measure. This is so great to read after reading the judge's order. They say Roc Nation's AI hallucination accusation is misplaced. The cases Roc Nation collects, Park v. Kim, Mata v. Avianca, Jimenez v. Fogarty, Carr, and Flycatcher, each involved a submission that cited non-existent decisions or authorities that could not be located at all. That is what hallucinated means in this context. No, you can hallucinate a holding too. Fabricated cases invented from whole cloth. Roc Nation does not and cannot contend that any decision cited in plaintiff's opposition is fictitious. To the contrary, its letter reproduces a table in which every entry is a genuine, correctly captioned, correctly reported decisions. The hallucination label is therefore inept, and the string of cases imposing sanctions for citations to imaginary decisions has no application here. This makes it so much funnier that Judge Willis says, we're going to pull out the dictionary and teach you what quotations means. If you want to mince and try to get very granular with how you want to interpret the word hallucinations, we're going to define quotation and quotation marks. Next, each of Roc Nation's 17 flag citations supports the proposition for which plaintiff cited it. Roc Nation's letter reduces to a table of 17 entries in which it says the quoted language does not appear in the cited authority. That characterization conflates two very different things. A fabricated quotation attributed to a case that says no such thing, and B, a paraphrase, synthesis, or lightly compressed quotation. What is a lightly compressed quotation? Oh my gosh. Do you think we could go to Urban Dictionary and create a definition for lightly compressed quotation? Or a lightly compressed quotation that faithfully states what the court actually held. The AI hallucination cases Roc Nation invokes address the former. Every entry in Roc Nation's table is the latter. The controlling Rule 11 question is whether each legal proposition is warranted by existing law. He points to the Federal Rules of Civil Procedure 11b2, and entry by entry, each is. Plaintiff responds to all 17 in Roc Nation's own order. All right, so he's going to say this issue with the quote, a serious matter. Plaintiff cited Salavera for the settled proposition that a Rule 11 sanction is a serious matter not lightly imposed. That is the decision's holding and disposition. The Second Circuit vacated the Rule 11 sanction and reversed the 1927 award, emphasizing that a sanction must rest on more than a losing position. The proposition is warranted by this case. No, it doesn't. That type of holding means that just because your case doesn't succeed on the merits doesn't warrant sanctions. That's not what Rule 11 is designed to do. If your case doesn't succeed, sometimes it doesn't succeed, but that doesn't mean that it was brought for improper purposes or any other violation comes into play. I don't see how this holding is relevant to cite at all. It seems like the issue is that the court used Rule 11 sanctions to award sanction. It were in a place that it was just, there was no finding of an improper purpose or something like that, of an actual Rule 11 violation. So this case doesn't even seem relevant, but okay. Kielba v. Milson. Merely because a claim proves unsuccessful does not mean it was frivolous when filed. True enough, but that's not the argument. That's not what Spiro's arguing in the motion for sanctions. So this wouldn't even be relevant anyway. Kielba holds that conduct is sanctionable only where a position is utterly lacking in support, which is exactly what Spiro's arguing. And that an unsuccessful claim is not for that reason frivolous. The quoted language states that holding precisely. The proposition is warranted. Next we have, it is patently clear that a claim has absolutely no chance of success / absolutely no chance of success. Plaintiff concedes that the quoted phrasing does not originate on page 388 of Story itself, rather that formulation derives from the earlier Second Circuit authority that Story discusses and applies, specifically Roddick and City of Schenectady from the Second Circuit and its predecessors. Story is a real binding Second Circuit decision that recites and applies the governing standard, and plaintiff cited it for the standard it applies, not as the originating source of the precise phrase. The underlying legal proposition that Rule 11 sanctions require it to be patently clear that a claim has absolutely no chance of success is the settled Second Circuit objective frivolousness standard and is warranted by existing law. The appropriate correction is to cite Roddick as the originating authority for the quoted language, with Story cited for applying that standard. A citation form correction, not evidence of a fabricated or hallucinated authority. All right, fair enough. Fair enough. Fair enough. But on this one, like, it still seems like this holding doesn't address the issue. I don't know where this came into play, but if this relates to the New York labor law, like, you shouldn't be discussing whether or not something just absolutely has no chance of success. You should be explaining why, based on the facts of the case, the law, specifically this whatever set of New York labor laws that you're relying on in your causes of action, could fit the set of facts as it relates to Roc Nation and Terrence Dixon. But anyway, cross and cross props. A shifting standard would sanction lawyers for making avoidable mistakes. Plaintiff cited cross and cross for the proposition that Rule 11 is measured by an objective standard fixed at the time of filing, under which courts resolve all doubts in favor of the signer, rather than a shifting hindsight standard. That is a decision's reasoning, and the quoted language captures it. The proposition is warranted. Yeah, does that case deal with amended complaints? Burns v. Bank of America, this is the utterly lacking quote. Plaintiff cited Burns for the utterly lacking in support formulation of the sanction standard, the same standard the Second Circuit articulated in Kiobel. The quoted phrase states that Rule 11 standard, and the proposition is warranted. Olivieri v. Thompson. So I don't get it. Is he... I don't get if some of these, if he's saying that the quote is actually there, or if he's just continuing to say, well, it's close enough. Next, we have the plain language of the statute limits its application to attorneys or others admitted to conduct cases. Olivieri holds that 28 U.S.C. 1927 reaches only attorneys and others admitted to conduct cases and not parties. The quoted language states that holding. The proposition is warranted. Yeah, and they go on, and a lot of it repeats itself. The quoted language states them, and the propositions are warranted. The propositions are warranted. The quoted phrases state that holding. The proposition is warranted. The quoted language states that holding. Propositions warranted. And so on and so forth. In each of the 17 instances, the case is real, binding, or persuasive, correctly reported, and cited for a proposition it actually supports. Where quoted language does not track the source verbatim, it is a paraphrase or compression that faithfully states the court's holdings, the ordinary work of legal argument, not the invention of fake law that the AI hallucinated cases condemn. But what's so problematic about this is the reason it's necessary to quote the holding. Sometimes holdings can be argued and perceived either way, or in more than one way. But you give it to the judge, you argue what you think your persuasion is for that given quote and why you think it supports your position. And you should make that argument in good faith. And you cannot be doing that in good faith when you manipulate the underlying quote. Was accidentally, earlier this morning, watching a case on a different judge's calendar call where it seems like the defendant was Ukrainian and a victim complainant was Ukrainian as well. And there was a translator translating on behalf of the victim. And the attorney for the defendant seemed to also be familiar with, well, maybe it wasn't counsel, maybe they had someone that was fluent in English and Ukrainian, and they were notifying counsel. I'm not sure. But there were several issues brought to the judge, like, hey, that's not exactly what the victim said. Like, the translator isn't giving the question the way you worded it. For one of the examples was like, and what's the reason you finally decided to move? And the way that the defense counsel said that the translator would translate it was something to more, was that one of the reasons you moved? Which is different. One of the reasons versus the reason you finally moved, two different ways to phrase things. So quoting something verbatim is necessary if you're going to argue your interpretation of it and why it applies to your case, but you're changing the direct quote. We can't tell if that's what was intended. We can't even begin to interpret what was meant by the holding if you're not giving us the primary source language. So, like, this right here, kind of like how I skipped through all of this, I can picture a judge reading this and being like, okay, you do not get why it matters that you're acting like, who cares what's in the quotes. Roc Nation's own submissions fail the identical citation audit it now invokes. They're going on to another argument. Before the court accepts Roc Nation's premise that citation discrepancies in a brief are so grave as to warrant striking it, well, that's what happened. Now we know. The court should know that Roc Nation's own submissions do not survive the same test. Plaintiff ran both Roc Nation's Rule 11 motion and its motion to dismiss memorandum through the same category of assisted citation verification tool that generated the table appended to Roc Nation's letter. The results are telling, and they cut against Roc Nation more sharply as against plaintiff. They say Roc Nation's Rule 11 motion fails the audit. Okay, so are these tables, is he going to give a table in here? No? So is that table just spit out? Like, is the table we saw in the Roc Nation filing something that a program would spit out? Like, is that the basis for Tyrone Blackburn saying, I know what audit program they use. They obviously use this program. Or is that just like a blind claim and we're not even going to get him pasting his comparison table to show us? I mean, I guess it really doesn't matter. We already have an order from the judge. We've got Roc Nation's Rule 11 motion fails the audit. Of 83 quoted passages checked in Roc Nation's Rule 11 motion, the tool flagged roughly 1/3 as incorrect. That is, as quotations, the tool could not match to the authority Roc Nation cites. Two categories of the tool's findings are especially significant because they mirror exactly the infirmities Roc Nation attributes to plaintiff's opposition. So first is misattributed quotation to a Supreme Court authority. Misattributed quotation to a Supreme Court authority. Roc Nation attaches substantive bad faith language that a party, quote, filed a frivolous lawsuit in bad faith for the purpose of extorting a settlement from the defendants. And they cite this to Bridge v. Phoenix Bond and Indemnity Company, a case from 2008, and the footnote says, holy moly. The United States Supreme Court's decision in Bridge v. Phoenix Bond and Indemnity Company does not, and I think this case, this argument from Blackburn is the one that Willis quoted in her order and compared. Like, this is how Blackburn said it. This is what Blackburn said Roc Nation was saying, and this is what Roc Nation was actually saying. They were actually citing another case, Bird. That was an underlying case that Bridge relied on. So this is the one that Judge Willis was like, no. But this footnote says that the United States Supreme Court in Bridge v. Phoenix does not address allegations of filing a frivolous lawsuit in bad faith for the purpose of extorting a settlement. Bridge is exclusively a civil RICO standing and proximate cause decision, unanimously holding that a plaintiff asserting a civil RICO claim predicated on mail fraud is not required to show first-party reliance on the defendant's misrepresentations to establish the cause of action or proximate causation. The decision's holding is confined to the statutory elements of a RICO claim at the pleading stage. It does not evaluate, address, or make any finding that any party filed a frivolous, bad faith, or extortive lawsuit. Consistent with this understanding, every circuit court to have applied bridge has treated it exclusively as a reliance and proximate cause precedent. All right. We cite underlying cases, more underlying cases. No court has ever read bridge as standing for the proposition that a defendant filed an extortionate or bad faith lawsuit. Roc Nation's use of the abrogated on other grounds by bridge, parenthetical, appended immediately after the extorting a settlement language, falsely implies that the Supreme Court in bridge engaged with and left intact Burns' bad faith characterization. It did not. Yep, this is exactly what her order contests. Oh, my goodness. My goodness. Let's see. All right, so this is from the order. Uh, let's see. Yeah, okay. So bridge and then burn. And this is the correct, this is what the judge is saying. Here's what Roc Nation actually stated. And the inset language was, had plaintiff actually read Roc Nation's motion, because this is from their letter in response. We haven't gotten to this responsive letter to what Blackburn is writing in the letter we're reading now. But they're like, well, if you actually read our motion, you would have seen that Roc Nation did not attribute that quotation or any other to bridge. We cited Byrne v. Netsat, and appropriately added, as a description of subsequent history, that the decision was abrogated on other grounds by bridge. So I'm wondering if what happened here is you run it through an audit program, and the audit program, the language, the learning model, can't distinguish. They saw bridge, they might have seen Byrne. The computing, they pulled up bridge. They were like, oh, Byrne is mentioned here in some part. And then they went, let's search bridge for these quotations. Nope, it's not in bridge. But bridge isn't going to quote Byrne in full. So the program, the auditing, based on what it decided to look at, its parameters, probably said, hey, that quoted language isn't in there. But it's because it wasn't looking at Byrne and the quoted language was from Byrne. Maybe that's why we shouldn't rely on AI to do all of our vetting for us. It's a good place to start. It can point you in the right direction. It can narrow the road. It can save some time. It can help you, give you ideas on where to start. But it shouldn't be the pass-through for your duty. When you have a duty of candor to the court, if this isn't court-related, if it's a duty to a client, if you produce written works for a client, what you give them should be your work. Your work. Or at least they should be in the know that, hey, we're agreeing that this is the result, and 25% of my work is going to be the generation of AI. Or heck, pay me, you generate something with AI, and I'll copy edit it. I'll improve it. I'll fact check it for you. Whatever the agreement is, it should be transparent. And here for attorneys, they have they have a duty. You've got Tyrone Blackburn saying that, oh, Roc Nation's actually doing these bad things. My AI is telling me that they used AI. And I'm only bringing that up because they're accusing me of using AI instead of verifying things myself. Which means he tripled down and continued to use AI and got it wrong while being called out for using AI and being wrong. Oh, so that was a long footnote. That was a journey. That was like up here somewhere, right? Where was that footnote? Yep, okay. So we're back up here. The verification tool, which apparently doesn't do a very thorough job if it's cases within a case, return no matching quote found in bridge. Yeah, exactly. And I think it's when you think about it, it's very easy to understand why, if you're telling something to look in bridge for a quote, when the quote is from another case, it's going to tell you there's no quote in that wrong case. But Blackburn doesn't seem to get it. He seems to think that this tool is infallible and that he should be relying on it here. This is so stupid to be doing. when you know that even if this was the nice judge, even if this was Judge Rochon, that you're going to have Roc Nation's attorneys, you're going to have every other attorney group of attorneys that's part of these proceedings on your ass because you just admitted here that you're relying on AI to do verification and then not doing human verification after the fact before you lodge accusations at opposing counsel. Just why would you do that? Why would you do that? So he goes on to say that Bridge is a RICO standing decision. It does not contain the quoted language Roc Nation attributes to it. That's precisely the species of citation error, quoted language that does not appear in the cited authority, that Roc Nation labels an AI hallucination when it appears in plaintiff's brief. Except that's not what you did with your brief. You didn't quote a case that happened to have a different holding somewhere else on a different issue. You just didn't have a real quote from anything, from anywhere. This is wild. This is wild. Quotations attributed to authorities the tool cannot locate at all. Quotations attributed to authorities the tool cannot locate at all for a substantial cluster. I don't know why it's written like repeating the title. For a substantial cluster of Roc Nation's quotations, the tool reported that the cited document not found. These include quoted passages attributed to Saltz v. City of New York, to U.S. to 1927, the rule of Civil Procedure 12F, so actual rules, and to a series of short-term, like when you rely on a case that you previously mentioned, which the tool could not resolve the underlying source. Is he not realizing what he's writing? Okay, so I think the tool might struggle. Like if I'm doing an identical citation to something that I just previously stated, like if I do Saltz v. City of New York, and then I rely on it 2 or 3 more times, and so my citation just says like id to represent that it's the preceding case, the most recent case I just cited. Is this verification tool going, let me see if this has the case, has the quote that's right next to it? Oh, I can't find what this is because it's not computing that it should be referencing the most recently mentioned case. And is Blackburn not realizing that and saying that all of these are returning cannot locates and blaming it on Roc Nation for falsely attributing quotations because the program can't work with this quite yet? This is a lot. How do you not? Maybe I'm off base here because I'm not the lawyer, but I can very much see an AI verification tool struggling to say, I don't know why this quote, I can't find this quote in whatever it is, because it's not going to compute and do the legwork to figure out what the previously referenced case was. Why would you put this in a filing? This is like not even trying. It's just like, oh, the audit returned a big number that's bad for Roc Nation, so I'm going to embrace it. Then he goes on, he says, these are the same audit results, quoted language the verification tool cannot tie to a locatable authority that Roc Nation characterizes as disqualifying when the tool flags plaintiff's brief. And I'm not even sure, it's not even clear to me. We keep saying that Roc Nation's using the same tool. Maybe they are, maybe they aren't, but their table didn't include any of this. So it seems like they at least did human verification if they did use the same tool. Then they say Roc Nation's motion to dismiss memorandum suffers from the same class of citation infirmities. The problem is not confined to the Rule 11 motion. When Roc Nation's motion to dismiss memorandum is run through the identical audit, it too returns a substantial number of quotations that either do not appear in the cited authority. So we're going beyond addressing the motion for sanctions. We're now dealing with something that isn't part of the letter back and forth. I say no matching quote found, or that materially diverge from the source language Roc Nation places inside quotation marks. Because Roc Nation asked the court to treat citation discrepancies as sanctionable misconduct, Plaintiff sets out the flag passages from Roc Nation's own dispositive brief, item by item, so the court can measure the moving party's submission by the standard it urges. So they give Cho v. Chu. Roc Nation quotes the TVPRA venture liability standard that a defendant is only liable if, and then quotes 3, which the beneficiary knew or should have known has engaged in an act in violation of the TVPRA. The source instead reads, which, all right, this is kind of hard to read because this big footnote. So let's do this. So we're comparing this with brackets. And all right, so they're swapping out section 1589 with TVPRA. Because I don't think the issue is going to be with the brackets around the beneficiary. But isn't that the same thing? Wait. 1589. This is the verification we should be doing, right? TVPRA might literally not be 1589. But if for the purposes of a filing, we're going to agree to use the phrase TVPRA, and we swap an interchangeable section that codifies TVPRA, that's not the same thing, especially if we're indicating with brackets our uniform naming schematic that we're using for consistency throughout the motion. TVPRA. Codified, respectively. You've got 2. You've got 1589 and 1591. 1589 is the forced labor one, which is the one of the ones at issue in this case. Is this what we're saying is a hallucinated quotation when it's in brackets? It's not like we didn't use brackets. This is the reach we're doing. So we're taking issue with, I should put this in a different color. This is, well, I'll put this in green because this is what Blackburn's like, this is what the source actually says. And then this is the issue. It goes on to say, it's 1589, not the TVPRA. Rendered as a direct quotation with brackets that indicate a swap of an interchangeable term. He leaves out that part that there's brackets. Oh, my goodness. Oh, I'm sorry you've had that experience, Mystery Machine. It's an expensive regret, I would imagine. Right? I say it a lot. Like, I hate that it takes money, time. You got to research and find a good attorney. But I wish everybody could be brought up to a level where the attorneys that we think are the best of the best, I wish they were closer to average. Right? I want what it means to be average as an attorney. I want that bar to be raised. Because it sucks to hear that somebody just has crap counsel. So let's go on. Maybe the next one. This is the first one you lead with, too. All right. Next, we have, for the proposition tied to the first amended complaint, we have Chen v. Kai. The tool returned, and he's acknowledging. He's like, the tool. Not saying the tool returned this, and I went and verified at the very least. That we just have a no matching quote found. And this is one of the identical cite things. Mueller v. Deutsche Bank says Roc Nation renders some characteristics that were consistent with VAT fraud as source text. The audit flagged the quotation. Again, for the bracketed parts. The bracketed and truncated rendering does not track the cited pages quoted. So this goes back, they're not giving the differences. He's not putting what was said versus what it actually reads. But if this is the same, where's my arrow? I just want to draw an arrow. If this is the same issue where this is a bracket issue, I say a no on this one. We're like 0 for 3 right now. And judging by the order, I think the judge found the same thing. SJV Choice Hotels. Roc Nation quotes that franchises were generally aware that sex trafficking sometimes occurred in their franchisees' properties, unjustifiably bridges the censure gap between should have known and might have been able to guess. The audit flagged this passage as not matching the cited source as quoted. All right, so that one might be an uh-oh. I mean, I don't know. Geis v. Weinstein Co-Holdings. Roc Nation creates a causal relationship between affirmative conduct formulation. The source language reads, furthering the sex trafficking venture and receipt of a benefit with actual or, in the civil context, constructive knowledge of that causal relationship, materially longer and differently framed than the compressed quotation. What? But the quotation, it's like he's giving the beginning of the quote and not the end, and then taking issue with it not being the full sentence. But it's unclear from this comparison if, like, we know that these words are apparently there according to this representation, and it's not addressed if this part is false, if this part is non-existent. It's like this is a total detour and not addressing any potential of a hallucinated part of a quote. It's just saying, hey, there was also something else before over here that they didn't include. And we stop before we can see if there's something else, which leads me to believe that this is not hallucinated language. We're just going to find another reason to gripe about it. And we probably didn't review what this audit spit out because we just threw it in here and relied on it. And the audit gave us, hey, there's a difference here. And we didn't care that that difference wasn't relevant to the argument we're trying to make here about something being hallucinated or not a direct statement, not real words. It's just noticing a difference because these words aren't also included. So this one is a no for me, dog. It's a no for me. I should get that sound clip. Noble v. Weinstein. Roc Nation cites Noble for the parenthetical that liability cannot be established by association alone, but the audit tied the pin-cited quotation to unrelated source language. And in quotes, it puts foreign commerce to entice or recruit, and there's a bracket, so another bracket, something young, reflecting a mismatch between the quotation and the pinpoint Roc Nation supplies. I don't know, it seems like it can't deal with brackets. Like, this audit seems like it can't handle brackets, or it's going to, out of an abundance of caution, if something's bracketed, which typically indicates a knowing change. It's an acknowledgement of a change for one reason or another. You're changing the punctuation, you're changing the spelling. If somebody says he, she, or they, and you're writing a news article and you want, for context, you want to put the name of who they're referring to, you swap with a bracket, he to Mr. Smith. Like, it's a flag that you are intentionally changing something and changing it for understanding or readability, but letting the reader know. It's not like I'm changing it, but just trying to let you not know that I changed it. So it seems like this audit, he's including when this audit detects a difference because there's bracketing. Like, but okay, it sounds good. We're up to number 6, and I think 1 is a possibility, and all the other 5 are X's. But as far as he's concerned, he's got 6 examples so far, and I think that's his goal. We're back to Geis v. Weinstein for a few. Roc Nation quotes that Roc Nation knowingly benefited. Look, this has a bracket. And it says benefits instead of benefited, which is why we have ed, benefited, past tense, in brackets. So this is the discrepancy we have with the direct quotation. We have a bracket. Oh man, we've got Geis v. Weinstein Co-Holdings again. Let's see if this one gives us something different. Roc Nation quotes from quote, from participation in other activities engaged in by the ... The source reads, participation in other activities engaged in by the... There's no difference. Okay, but they put an ellipses. So the issue here is that there isn't more. And this isn't a hallucination. This would be something that you argue. This would be, you argue, is this persuasive or not? Is it good for your case? Does it stand for what you're saying? Does it support your argument? Does it contradict it? You should be arguing this. This is not a hallucination. Levin v. Sarah Lawrence. Roc Nation quotes, because the complaint, we have a bracket here, let's see if it's a bracket issue. Because the complaint does not give rise to the plausible inference that Roc Nation benefited financially or by receiving anything of value. The TVPR claim, and there's an ellipses, the source reads, benefited financially or by receiving anything of value. And then this is in brackets, and a comma in brackets. The TVPRA claim against SLC must be dismissed. So you want Roc Nation to include the part that relates to Levin v. Sarah Lawrence call? They don't need to include that in their quote. And again, an ellipses is indicative of you're skipping a few words that don't pertain, but do not take away from the holding. So, oh my gosh. I couldn't be an attorney. This would drive me nuts to have to do. Like, seeing it happen once, this is like a novelty to me right now. But I couldn't deal with this, like, as a 9 to 5. I understand now why you get big bucks to write these things. Not just because some legal writing is very, very good. And I want to do a stream this weekend on something that Andrew Fleischman wrote and put together, and listen to some oral arguments in a wrongful conviction case he just secured wrongful conviction compensation from. And another case where he just kind of tore ass against, it's a civil litigation. His legal writing, it's super short, super concise, great writing. That man is worth his money. I don't even know his rates. I'm sure he does pro bono work too. But I love good legal writing, and there's good legal writing is worth every penny. But I think there's also billable hours just for the patience that sitting here and like reading this must take. So yeah, this weekend let's try to do an Andrew Fleischman appreciation stream. We'll listen to some oral a hearing. It's not oral arguments. It was a hearing with arguments for wrongful conviction compensation, and we'll read the decision and his underlying brief on behalf of his client. So that'll be fun. We'll do that this weekend. But yeah, so I think a lot of these are just going to be brackets, or like the quote could be longer, but it wasn't. So here they say impose liability for violations of employment law on the constructive employee, but the source reads constructive employer. All right, I mean, that makes sense. But that seems like a typo. So If this is like the one example where I'm like, yeah, that is a difference and I can see it changing the meaning, I think this can be easily explained by something that's not intentional or not just due to a lapse of human verification, because human verification can mix employee versus employer. All right, so the next one has a bracket. Like, we've got an ellipses here, an ellipses here. Let's see. This just says the audit pulled unrelated source language. This is saying no match, but these are all id cases again. So we're back to id cases not finding a match. An ellipses. This just says the audit flagged the quoted passage. This one has brackets. This one says no matching quote. So we have two that say no matching quote found that don't seem to be id sites. That's an identical citation. And this is an integrated enterprise versus single integrated enterprise. So not changing the meaning, but maybe quote that appropriately. Yeah, but most of these, you could see there's an ellipses, an identical citation, an ellipses. Which again, I think that's a great reason why an audit might not know what to go look for. All right, so back to the rest of the arguments. This is the end of the examples. I say that's not a handful of stray discrepancies. I mean, I disagree. I think we take the employee-employer. That is a discrepancy that changes the meaning, but it can be explained by a typo. But they say it's a systemic pattern running through Roc Nation's dispositive brief of the very citation practices, truncated quotations, bracketed alterations, compressed paraphrase rendered as direct quotation, and pinpoint mismatches that Roc Nation now asks the court to treat as sanctionable when they appear in plaintiff's opposition. At least two of those items, Fowler's constructive employee and constructive employer, yeah, so they're going to go with the one that can change the meaning, but like I said, and the several no matching quote found results are precisely the species of error Roc Nation labels AI hallucination in plaintiff's brief. The equitable consequence follows directly. It would be fundamentally unfair to strike plaintiff's opposition for citation discrepancies identified by an AI audit. All of this is supposed to be about the counsel's verification. And he's said over and over and over, AI audit, the tool said, when the moving party's own motion and dispositive memorandum fail the identical audit at comparable or greater rate, including a misattributed quotation to the United States Supreme Court and a substantive misquotation that inverts a holding, Fowler's employee and employer. A standard that would doom plaintiff's brief would equally doom Roc Nation's own submissions. The court should decline to adopt any such standard and should instead resolve the motions on their merits. Next, the Star, Mark, and Cooter and Gell are real, binding, and support the propositions for which plaintiff cited them. The Star Mark, in particular, confirms that Roc Nation's own safe harbor service was defective. So Star Mark was where we had like the bulk of the citation issues pointed out. Roc Nation singles out on two further authorities, Star Mark and the Cooter and Gell, as though they were invented or misused. They were neither. Both are real, both are binding, and both stand for the propositions plaintiff advanced. While that language seemed to say the opposite. To the extent plaintiff's opposition rendered a compressed paraphrase as a direct quotation, the underlying propositions require no correction because they are what these decisions hold. Star Mark holds that the safe harbor is a strict procedural requirement keyed to services under Rule 5, and Roc Nation did not properly serve its Rule 11 notice. Plaintiff cited star mark for the safe harbor propositions developed in Section 2 above. That Rule 11C's safe harbor is a mandatory procedural condition, and that the 21-day clock begins to run only upon service of the motion. Star mark holds exactly that. The Second Circuit quotes the rule's command that a Rule 11 motion must be served under Rule 5 and holds that the safe harbor provision is a strict procedural requirement. It further holds that an informal warning in the form of a letter without service of a separate Rule 11 motion is not sufficient to trigger the 21-day safe harbor period. And quotes Gal approvingly that service of the motion itself is required to begin the safe harbor clock. The rule says nothing about the use of letters. What? The panel likewise affirms that only conduct explicitly referred to in the instrument providing notice is sanctionable. Those are the exact propositions plaintiff advanced, and they are dispositive here. The controlling point is the one star mark makes textually. The safe harbor clock runs only from service under Rule 5. Rule 5b2e authorizes service by electronic means only where the person consented in writing. Roc Nation transmitted its Rule 11 notice to undersigned counsel by an email alone, without service by any method authorized under Rule 5b2a through d, and without the written consent to electronic service that Rule 5b2e requires. Undersigned counsel did not consent in writing to service by email. Because valid service under Rule 5 is the event that starts the 21-day period, and because that service never occurred, Roc Nation's safe harbor clock never began to run, and its Rule 11 motion is procedurally barred under the strict procedural requirement star mark describes. So understood, star mark is not a citation error and is not averse to plaintiff. It is the binding Second Circuit authority that defeats Roc Nation's own motion. The pinpoint quotation Roc Nation flags will be conformed to the decision's exact language, but the proposition it supports is precisely what the Second Circuit held. That's a quick way to note. Cooter and Gell is controlling Supreme Court authority on Rule 11's deterrent purpose and the deferential standard governing sanctions. Plaintiff cited Cooter and Gell for the propositions that the central purpose of Rule 11 is to deter baseless filings, and that Rule 11 must be administered with the restraint reflected in its abuse of discretion standard of review. Those propositions are the heart of the decision. The Supreme Court holds that the central purpose of Rule 11 is to deter baseless filings, that the rule is intended to make attorneys stop, think, and investigate more carefully before serving and filing papers, and that Rule 11 and Rule 41A1 are both aimed at curbing abuses of the judicial system, and that an appellate court should apply an abuse of discretion standard in reviewing all aspects of a district court's Rule 11 determination. Each of those is verbatim or near verbatim, and each supports the use plaintiff made of the case. Aren't some of those quotes the quotes that Roc Nation actually threw in their letter as what was correct? All I'm thinking of is in a very early filing, I think it maybe was the initial complaint, there was like a section that went off the wall, and it was from Terrence Dixon, from Tyrone Blackburn, and it was like acting like all of a sudden out of nowhere in this motion, it was acting like a response. So I'm pretty sure it was the initial complaint. And there was like this side story, bunch of paragraphs, as if it was defending Desiree Perez, who'd be with Roc Nation. And it was almost like somebody was using the assistance of a language learning model of whatever sort to help prepare that filing, that complaint. And it got lost in the sauce and started acting like it was replying in defense and arguing that Desiree Perez had no knowledge, wouldn't have known these things, which would be a party that Terrence Dixon was bringing causes of action against, defending itself in the very complaint. And it was very, very weird. It was very, very bizarre. It was very, very bizarre. And I'm just thinking of that now. I'm just thinking of that now with like, I think some of the things. But anyway, I feel like these weren't necessarily all the quotes that they were relying on, and some of these quotes, which may now be correct, are actually from the Roc Nation letter with their correction. But anyway, they say each of those is verbatim or near verbatim, and each supports the use plaintiff made of the case. Then we've got plaintiff is candid with the court about the one point on which Roc Nation's flag has surface appeal. In restating Cooter and Gell's holding, plaintiff's opposition inadvertently omitted a single word, quote, not, so that the sentence reads as though a voluntary dismissal eliminates a completed. What? Oh, so it's okay when you make a typo. You excluded the word not as a typographical error. Oh, Lord help us. Oh, yeah, they were right that I left out the word not. That was just a typo. What Cooter and Gell actually holds is the opposite, and is precisely the proposition plaintiff intended to convey. A voluntary dismissal does not eliminate the Rule 11 violation. Why would you be intending to convey that? That doesn't help you at all. Because the violation of Rule 11 is complete when the paper is filed. This is what you wanted to limit it down to. You wanted just to tell the court that the violation is complete when the paper's filed because you wanted to start with the first amended complaint as your time clock. Oh, oh, oh my God. Okay, I'm sorry. I think YSL Kel saw it like, oh, you're almost to the end. Oh my God, dot, dot, slash star. That's crazy. Okay, we're going to get to that. Let's finish this letter. Blah, 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 blah. The dropped word inverted the meaning of a single sentence. It did not invent a holding, misidentify a case, or attribute language to an authority that does not contain it. This is the paradigmatic Scrivener's error, categorically different from the AI hallucination of fabricated authority that Roc Nation's letter alleges. Plaintiff does not rely on Cooter and Gell for any proposition that a dismissal eliminates a completed violation. Plaintiff cites it for its holding on Rule 11's deterrent purpose and the deferential abuse of discretion standard of review. Holdings that are verbatim in the United States reports and that Roc Nation does not dispute. I feel like see, this is why I get confused reading this, because I really feel like Roc Nation had to bring in that whole quote to say, like, hey, this quote shows that this case doesn't hold what they're saying it holds. I don't think that the issue is that plaintiff included that quote but left out one error. I think they ignored that quote entirely and were just trying to focus on this. But Roc Nation brought in that other line to say that's not the holding. It's quite the opposite. And then they go on to say the opposition brief stands and the motion should be denied. The court did not respond to Roc Nation's July 3rd letter and has not directed plaintiff to file a corrected brief. Plaintiff files this letter solely to place a substantive response to Roc Nation's accusations on the docket. And as set forth above, each citation in plaintiff's opposition is to a real, published binding authority, cited for a proposition it actually supports. Roc Nation's letter does not identify a single fabricated case, a single non-existent decision, or a single holding that plaintiff attributed to the wrong court. The opposition brief stands. Because plaintiff's opposition is legally accurate, factually grounded, and free of fabricated authority, there is no basis to strike it, deem it defective, or deem Roc Nation's dispositive motion unopposed. Plaintiff respectfully requests the court deny Roc Nation's request for any such relief and proceed to resolve the pending sanction motions on the merits. We thank the court for its attention to the matter. Now, Roc Nation filed a response to that, and they're like, no, we stand by, we did human verification. We didn't use AI. We stand by our citations. And let's go. I am excited. Let's go see. Where do we have this filed? Dot, dot, slash star. The goat. The goat. All right, so let me just check. Maybe I'm on the wrong docket because there's two, and that's annoying. All right, July 10th. Oh! Okay, the letter is visible. All I see is the letter. It looks like there's something else that's sealed. Okay, guys, so As ... / noticed, Joe Tacopina just filed a motion to initiate criminal contempt proceedings. Criminal contempt proceedings. So, he's currently got an order to show cause. He just got his opposition motion stricken down, and Judge Willis said sanctions are forthcoming in relation to Roc Nation's Rule 11 motion for sanctions request. We're waiting for that order to come through, maybe today, maybe next week. And now we have Tacopina for Fat Joe moving for criminal contempt proceedings. Your Honor, I am counsel for Joseph Cartagena in the above reference actions and right, pursuant to Your Honor's individual practices, to seek leave nunc pro tunc to file Mr. Cartagena's letter motion contemporaneously filed here within under seal. In the letter motion, Mr. Cartagena respectfully requests that the court commence criminal contempt proceedings against Tyrone Blackburn for willfully violating Your Honor's July 8th, 2026 order to show cause, entered July 9th, 2026, and the court's December 8th, 2025 stipulated confidentiality agreement and protective order. Specifically, just over 5 hours after the court entered its order sealing Exhibit J to Mr. Blackburn's motion to withdraw as highly confidential and directing him to show cause why he should not be held in contempt for publicly disclosing it, Mr. Blackburn emailed that very exhibit to a member of the press. It wasn't me. It wasn't me. And we're saying email. We're saying email. Who got the email? Who got the email? Because my gut, either somebody reported, and the reporting says, in an email received after a request for statement or whatever, or somebody went to the party directly and said, hey, he emailed me trying to get me to publicize this. Wasn't me. But I think this is very specific. Seems like there's some knowledge here. Maybe not. Maybe this is just a baseless guess, like when Tyrone Blackburn said that Cartagena was coordinating with the media. I don't know, but this seems like specific. And it says a member of the press. I wonder who it is. It was Shaggy. It was Shaggy. Whew. Due to the current need to prevent further dissemination of material protected by the protective order, Mr. Cartagena respectfully requests leave nunc pro tunc to maintain the letter motion under seal. Sealing is appropriate because the letter motion necessarily discusses the highly confidential motion exhibit protected by the protective order. So I'm wondering if like that also includes more details on this. So this is important though, because he's saying just over 5 hours after the court entered its initial order sealing and directing him to show cause, he's emailing it. Maybe he's going to say, maybe I didn't see the order. Maybe I didn't see the order. I didn't see it. I don't check my email. So many cases. I mean, yeah, that's where my brain is. I mean, this is just worded very precisely. Emailed to a member of the press. And honestly, I can kind of picture it. He has these antics. Blackburn has these antics sometimes where I can kind of picture him like, and your mother, like sending it to someone from TMZ. Like he has this lawsuit he recently initiated against TMZ and Levin. I could picture him like emailing it to someone that he views in that light. Like, why don't you publish this? Like, you're going to publish all this bad stuff in your scheme against me. I don't know. I can picture him doing that very stupidly to someone who would very obviously run it back to Fat Joe's counsel. I can also picture just another person going like, hey, you know what? I got this, but from my awareness, when I look at the docket, it looks like he was ordered not to be disclosing this. And I feel like because I shouldn't be getting these communications. So I don't know. I don't know. I don't know. But yeah, Adventure ends like, we understand the need for stealing. We'll take what we can get publicly. Yeah, I mean, I'll take the letter. I think it's a huge deal. Criminal contempt proceedings. And it just says Your Honor. Ah, it's to Willis. All right, it's to Willis. It's to Willis. Might happen. It might happen. So, and at the very least, we're going to have like 2 order to show cause hearings coming up. Yeah, maybe New York Post, Daily Mail. But wow. Well, what do you guys think of that? And this is, for this live stream, I'm going to clip this out, this little tidbit, if you will. But what do you think of this? Whether you watch the full live stream or you're just catching this news, we finally have an attorney aiming for criminal contempt. And where was it earlier? Where was it earlier? Hey, Ken. Good to see you, Ken. Earlier in the chat, we had I hope we get contempt. And now we have the attorneys requesting it. I'm scrolling and looking for it, but I think I'm glossing over it. But shout out to you for that comment. It's like you saw the future. How many episodes of the Netflix series will this case take? Look. Who knows? Who knows? Who knows? Maybe we'll get a lawsuit against Netflix if that happens. Oh, but what a Friday. What a Friday. That is the only... I mean, on the docket, of course, I see the sealed letter motion. But other than that, everything else is what we just caught up to. So we got caught up with the Rule 11 sanctions. We just don't have the order yet, right? So I think the next thing, it could be something in relation to this. It could be maybe Blackburn's going to file a response to the order to show cause and all of that relating to the withdrawal and attaching the exhibit in the first place. I don't know, guys. There's going to be a lot of motion in the next few days and weeks with this case. And remember, what is it, July? Where's the listen in line? I don't want to say the date wrong. July 21st, 10:30 a.m. There is going to be a public listen in line for the motion to withdraw as counsel. Now, this is a motion to withdraw as counsel where there's these outstanding issues, orders to show cause, now possibly criminal contempt, all while Tyrone Blackburn's trying to get up out of there. I don't think withdrawal works like that. They're going to let him withdraw, I think, ultimately. I don't think you can't let this person continue to represent a client. But what I'm saying is, I don't think you're going to just be able to withdraw and not have to deal with anything else that's presently hanging over your head as it relates to your conduct as an attorney of record in this case, right? So I don't think you're going to get up out of here and just drop off this April 2026 deposition, voluntary interview, whatever you want to call it, then fail to abide by the court's order and just, oh, well, I withdrew. You don't have jurisdiction over me anymore. I don't think we're going to be able to do that. So while I think he will no longer eventually at some point be counsel of record for Terrence Dixon, I don't think he's going to be off the hook for these shenanigans. Willis does not seem happy with what's going on as far as his AI hallucination accusations and his own use of AI citations in response to Roc Nation's filings. There's this order to show cause. There's just a lot. There's just a lot. So I'm glad. Kel says, I Googled Blackburn sanctions and there are several articles about the July 9th withdrawal filing. I'm very glad to see it. I think this is the type of thing that I think sometimes the embarrassment, the publication, the transparency, people being able to see it is what would deter it more than anything else. So, I mean, financial sanctions might be around the corner. Criminal contempt, those might be deterrents too. But for some people, it's the embarrassment. The embarrassment can get the job done. So, with that being said, guys, happy Friday. Hope everybody's ready for the weekend. If something files late, we might be back. We might be back. If not, I want to get together this weekend and talk about some other cases. If something happens here, this might take precedent. This might come first. But stay tuned, hit the bell if you see like an Alex Spiro thumbnail, Joe Tacopina thumbnail, Tyrone Blackburn thumbnail. It's something related to this web of cases and ancillary side stories that have emerged. So looking forward to whatever the next update is. We'll talk about it. We're going to keep pushing off the 3 lawsuits that have been brought against TMZ, Fox, Joe Tacopina by Tyrone Blackburn. Those are bulky, those are meaty, and quite frankly, I'm not really looking forward to something that might be AI slop. Like, I'm pretty concerned that those 300 and some combined pages for those 3 lawsuits aren't going to be fun or interesting reads, and they're going to be padded with stuff that might not even be real case citations. I just got to be on guard for it now based on the history of the filings that we get from this particular attorney. So eventually we will talk about that in more in depth though. Other than that, /star, thank you for coming in here with the, like, hey, Tacopina just threw this out there on a Friday night real quick. Thank you so much for that. You guys all have a great weekend. See you somewhere out here in these YouTube streets or next time we get together. Bye, guys.